How are you?
Hello, my friends. Hello, my friends. Thank you so much for coming to join Mark and I. Today is Monday, July 8th, 2024, and we are coming to you with some hot off the presses breaking news. My phone has been blowing up this morning. Mark was texting me. I was out of place getting my gray taken away, getting my hair done. There was no service. And I come out and I'm like rushing home. I had to pull over on the side of the road, set up the live stream. Here we are because we are here for you. Did you even get a chance to read this motion to dismiss, Mark? This is explosive, right?
I did. Yeah, this is not common, obviously. Um, it is probably something you can classify as a bombshell. You have apparently 25%, if my math is right, of the deliberating jurors who reached out on their own to the defense to say, whoa, something happened here. That's not right, which probably also tells you they did not watch the news during the trial, but they were watching after. One can only assume they saw some of these nonsense reports by self-styled journalists who claim they knew the breakdown of this and that and felt compelled enough to reach out to two lawyers separately, all the jurors unknown that the other ones were contacting, if you believe that. Um, two of three charges possibly acquitted. Certainly the murder, they all seem to, the three agree on that.
Let's read it. Let's read it. Because a lot of people have not had a chance to read it, including me. So I want to read through it. Are you good with that?
Yeah.
I know that you're brief writing. So if you need
I need
to pop
a break.
off.
It's a good break.
Oh, it's a good break. Oh, this is a good break, my friends. All right, you guys, this is explosive. Filed this morning is the defendant Karen Reed's motion to dismiss with regard to her trial. And this is what it says. I'm going to read it to you because I know so many of you are listening with your headphones on or at work and your headphones off and your kids are in the room. We're going to read through this motion together. But Mark and I said when we were watching the verdict come in, and you called it, right? And the judge said, I'm not going to send you back to go deliberate. I'm going to grant a mistrial. I'll come in and I'll speak to you privately. And she dismissed them. And you were saying, well, wait, we need to hear if she's going to, it's okay, great that there's a mistrial, but we need to know if they've acquitted on any of the charges.
Right. So just to lay the foundation for what you're about to do, there were three separate offenses. They weren't literally, lesser included offenses contained within the same charge, which is kind of a different situation. And when the jury came back and said that we have been unable to reach a verdict, I remember in real time saying, well, on which counts? I mean, it is not out of the realm of possibility that there could be a verdict on some counts, which of course would have to be taken out of a retrial. And there was no discussion about it. There was no asking the defense lawyers if they wanted to be heard. There was nothing. She just said, okay, we're out of here. And the instant concern was, well, how do we know whether it's all or one? We can't see the verdict sheet. We don't know how it's written. We don't know anything. And so then we just assumed, I guess that means it's across the board, but that's kind of difficult to know. And here you are a week later, and this is now a full-fledged fiasco with a capital F. I mean, this is a disaster. Also, you can't dismiss the possibility that the defense is going to want the judge to be a witness, which of course is virtually unheard of. But, what did the verdict sheet show? What was said in those conversations with the jurors? Did any of the jurors say, well, wait a minute, we thought this? I'm not suggesting they did or they didn't, but it stands to reason that the judge could be somehow a fact witness in part of this. And certainly Jackson and Yannetti will be, which is why they brought in another lawyer almost certainly to file the motion.
Yeah.
Because they may have to testify. They are going to ask permission to speak to other jurors and get affidavits because Massachusetts has this procedure apparently that forbids people from contacting jurors after the verdict, which is different than other places.
What? It does? Was this new? Because we didn't know this. I don't
So they had a beg in their motion for the right to,
Well, let's read it. Let's read it, and we can pause to discuss as needed because I haven't read it yet. So this is going to be a real reaction video from me.
Okay.
And let's take a look because you and I both. I thought the verdict sheet. I thought the jury instructions were incredibly confusing. And I said this. I don't think you were even on with me. I'm like, I have a law degree, and I've been practicing law for 30 years, and these jury instructions are confusing to
A
me.
mess. They were a mess.
And when she said to them, "Oh, well, I'm going to send you back with a copy, but whatever I say to you now is going to, you know, supersede the jury instructions," or whatever she said to them and whatever lingo. And I'm like, okay, they can't take notes. How are they going to remember? The whole thing was fakakta, and this is what you get. And I knew, and we hadn't heard from any of the jurors except the alternate went to the media. Nobody else said a word, and we said we're never going to know the split. And you said, perhaps after she went to have her little chat with them privately, she said, she may have given them a speech like, if you do talk to the media, this could, affect a retrial, right? So apparently they went to the defense firm instead, but we're going to see.
Yeah. One last thought, not about the motion itself, but just this whole process. This is just another black mark on this just complete joke of a public trial because people already think this case is so messed up that there are so many problems, so many sketchy things going on. And less than a week later, you now have very credible allegations of an acquittal on 2 of the 3 charges. And whatever ultimately happens with this process, which we can talk about in a few minutes, it is just another bad look for what's happening here. And there's going to be people on either side of this who are going to start alleging that there are more shenanigans going on one way or the other. And the reality is they're going to ultimately, there's going to be jurors who most likely are going to have to testify in court during this. And it's just another terrible black eye for the DA as well, for their possible retrial, assuming that there is 1 count or even more left to retry. They've been kind of living off this not warranted, quote unquote, good press of the verdict favored them. So said some of these random people online when apparently,
right. The fact that you called them self-styled journalists was very kind.
Well, yeah, no, and I mean, the guy just stole it off a tweet from Twitter, and all these people. It was like an integrity test for all the other ones who ran with it. And the irony is, they may very well have put this issue to the forefront and led to the motion because there's no reason to know that the jurors would have thought that this meant anything other than this is just what we do.
Right.
And it may very well be that these self-styled journalists and just online trolls and losers may very well have led to this happening. So round of applause.
Yeah, thanks guys. Thanks. Props to you because the jury was so outraged that you were lying about what went on in the jury room that they decided to come forward.
That may very well be what did it. You don't know.
Defendant Karen Reed's motion to dismiss. If you want me to pause at any time, just let me know.
Yeah, sure.
Now comes the defendant Karen Reed by and through undersigned counsel and hereby moves this honorable court pursuant to the 5th, 6th, and 14th Amendments to the U.S. Constitution and Article 12 of the Massachusetts Declaration of Rights to dismiss counts 1 and 3 currently pending against her on the grounds that the jury reached a unanimous decision to acquit her on those charges. And alternatively, because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Ms. Reed was not guilty, and therefore a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions.
So just the words manifest necessity, those are term of art, those are real words. It's not just creative writing. Those are the buzzwords you need in order to make a finding of if there is a mistrial allowing a retrial. There has to be a manifest necessity. And what they're arguing is that obviously if she was acquitted and the court accidentally issued a mistrial, that's not a manifest necessity warranting a retrial on those counts. So that's not flowery writing. That's actually legal.
Buzzwords.
Yeah, buzzwords.
The buzzwords. The ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of power to the American people, citing Erlinger versus the United States. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seeks to mitigate the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of, quote, pretended offenses, end quote, and, quote, arbitrary convictions, end quote. Prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact that Parliament and the Crown had deprived them, in many cases, of the benefits of trial by jury. After securing
This
their
is flowery
independence,
writing.
well, it's a citation,
Yeah.
so it's nice. I mean, it goes all the way back to the Declaration of Independence, which, by the way, it so happens was, Boston was the center of everything in the
Yep.
beginning of our country. So this is quite ironic that this is happening here. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. What is so interesting about the John Adams quote is that the judge quoted John Adams in like all of her opening, before she even like read the jury instructions. The Adam Lally quoted John Adams during his closing, and this is like a perfect like, you guys love John Adams so much. Here's what else he said.
Yep.
Right?
Yep.
It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. The double jeopardy clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. And that was also a quote. That was not something that Alan Jackson and or the new attorney who they hired to step in, the big guns. I'm not sure who signed this, but I also, in addition to this, have them affidavits of both Alan and David.
New lawyers signed it because Jackson and Yannetti are potential witnesses. So that makes perfect sense.
Yeah. Here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors, indicating in no uncertain terms that the jury had a firm 12-0 unanimous agreement that Ms. Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes reprosecution of Ms. Reed on counts 1 and 3 and mandates dismissal of those charges. Alternatively, to the extent the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue and that the court authorize defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her prior to indicating to the court that they could not reach a verdict on the 3rd charge alone.
So that last part is in English just means they want an evidentiary hearing. They want jurors to testify. They want the lawyers to testify, and they're asking permission to develop further evidence from the jurors, which again, in Massachusetts, my understanding is they can't approach jurors without some kind of order from the court. But to not allow that in these circumstances would be outrageous, because if nothing else, you have 2 lawyers who have submitted under penalty of perjury, both trial lawyers, saying this happened. Notwithstanding conspiracy theorists and lunatics online, courts take that very seriously when real lawyers under penalty of perjury claim this happened. So at a minimum, there has to be further factual exploration of what's going on here. It would be unconscionable to not do that.
It's insane. And so I mean, we're going to move on and read this, but I'm wondering if they filled out the verdict sheet and they checked not guilty on counts 1 and 3, and somehow nobody looked at it.
I'm almost that can't be the case, only because if that's true, then this is like a judicial misconduct scandal, because the judge would have seen that. And I can't believe that she would literally say, because you're telling us it's a hung jury, I'm just going to ignore that you checked off not guilty and would not make an inquiry about it. On the other hand, you go back to that conversation she had with the jurors. She has to be, in my view, a witness in this, because if you're the DA, you actually, I think, want her to be a witness, because presumably, if your theory is that none of the jurors at that time told her, but wait a minute, we actually acquitted on one or two counts, you would want, if you're the DA, you would want the judge to agree with the jurors and say that never happened, which makes her a witness. But ultimately, this may be the back door to get rid of her for the second trial.
Right. Because she's going to have to come in and testify. What if they've told the defense, hey, we told the judge this in chambers when she came for our private talk.
What if they don't believe her and want to cross-examine her aggressively, and it gets hot? I'm not saying it will, but it could. And you now have a situation where, because the judge is entrenched as a witness on a factual issue that relates to a retrial that she would be presiding over, this is a huge break for the defense on that alone, because depending if this goes to a full-fledged hearing and the judge is involved, there's just no way that she should be allowed to preside over a retrial.
Yeah, agreed. Background. On June 9th, 2022, Ms. Reed was charged via 3 separate indictments with murder in violation of Massachusetts General Law, Chapter 25-1, Count 1, vehicular manslaughter in violation of another law, and leaving the scene of personal injury or death in violation of MGL, Chapter 90. So they are saying the jurors contacted them and said, no, we acquitted on count 1, which was murder in the second degree. And we acquitted on count 3, which was leaving the scene of personal injury or death. And we were hung on only the second count, which was vehicular manslaughter. Yeah. That's what I'm gleaning from this.
Which is also goes back to the problematic issue that they were willing to accept, at least for purposes of this convoluted deliberation, that the ARCA evidence was not the be all end all, because none of this makes any sense if that was accepted. So there's always that in the back, nothing to do with this motion per se, but just an observation of what's going on in there.
Like if there were one holdout who said, 1 or 2 holdouts who said, all right, well, I don't think she intended to do it, so I'm not going to agree on murder. So we can all agree on that, and not going to agree on I don't know why she'd say leaving the scene.
It's weird when you get to the affidavits, and I know you're not there yet.
Oh yeah, let's get there.
They do appear to have been quite divided on the second count, which to me is bonkers in light of the car accident. But that's also the count that would involve the drunk driving component of it too, which is interesting. And you have to wonder if that was illogically outweighing other things, because there was some degree of evidence that she was driving in an intoxicated condition. But none of this makes any sense to me, but just an observation.
Yeah. Yeah. A jury trial began on April 16th, 2024. On June 25th, 2024, the jury began deliberations. On July 1 of 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. See Alan Jackson affidavit. The note was not presented to counsel for review.
Stop right there. That's a red flag. Not a Massachusetts lawyer. I get it. All disclaimers apply, but in trying, too many cases to count, it's unheard of when a note comes back that the judge will not instruct the clerk and say, here it is. And then the note gets marked as a court exhibit, which I'm sure it did here too, but to not allow the defense or the prosecution, for that matter, to look at it and add any comments, questions, or whatever on the record is never heard of that. But anyway.
Never have either. And if you want to watch the chat, if there's any Massachusetts attorneys who know that if that's a thing, attorneys are not authorized to see any jury notes. I mean, I find that
can't be. I mean, they have to preserve everything for appeal, and who knows? I mean, look, they indicated they read the note verbatim, so they're not disputing, I guess, what the actual content was, but the idea that it was not shown to them is just that's weird. The whole
we also thought it was unheard of that they couldn't get readbacks, but we've since learned that is a Massachusetts thing.
Right.
Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. Footnote 1 says, while the juror's note as read by this honorable court indicated the impasse was on charges, it did not say whether the charges were those within count 2, i.e. the multiple ways to find guilt on count 2, or extended other counts. The affidavits attached herein indicate the former, not the latter.
This is the problem with the convoluted jury instructions, the convoluted verdict sheet, even when it was fixed, and the judge's ultimate failure to say, I need to make sure, what are we hung on? I mean, I got to tell you, the big loser in this whole process is Canoni. She looks awful in all of this.
Not good.
Nope.
In short, neither defense counsel nor the defendant consented to the mistrial, and the court never ascertained from the jury whether its deadlock was in relation to 1, 2, or all of the charges in the indictments.
What we were talking about last week.
And we're like, okay, she's not even going to inquire, ask, or yeah. I don't remember if when she was handed the note, was she also handed the verdict slip that was just blank, or just the note?
We don't know, because we don't even know how the verdict sheet was filled out, if it was filled out. But again, it's the judge's responsibility to protect the record and make sure something is done, and to leave this look, if we can see it as just online, like the guys from the Muppets watching what's going on and commenting on it. But if we can, like from the peanut gallery, say, well, how do we know what the hung jury is on? How does a judge who presided over a trial like this, who had 2 notes saying we can't reach an agreement, at no time say, I just want to make sure that, we're on the same page when you say you can't read an agreement? It's mind-boggling.
Wow. The following day, the very next day, on July 2nd, Alan Jackson was contacted by a juror in this matter, Juror A, who stated that he or she wished to inform him of the true results of the jury's deliberations. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count, second-degree murder, was off the table, and that all of the 12 jurors were in agreement that she was not guilty of such crime. The jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene of injury with injury or death.
The description of the murder count there could not be any more unequivocal on what's happening. There's less detail about the third count, but to say that the juror, according to Jackson, who stated this under penalty of perjury, that's what I was told. That's a problem. That's kind of a big deal.
Yep. And I can see why they did not. I mean, they can't submit affidavits of the juror, because that would compromise their identity and that would dox them. So she's going to have a hearing on this if she doesn't outright, and we'll see. But let's keep going. Another day later, on July 3rd, Attorney Yannetti was contacted by 2 different individuals, hereinafter Informant B and Informant C, who had received information from 2 distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. See David Yannetti's affidavit. Informant B sent Attorney Yannetti a screenshot he or she had received from someone, hereinafter Intermediary B, of a text message that Intermediary B had received from Juror B. In that screenshot, Juror B texted the following to Intermediary B: it was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose, or even thought she hit him on purpose, or even thought she hit him on purpose. And then that says sick, as if that was what it said. Yeah. Informant C had been in contact with another individual, Intermediary C, who's a co-worker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent Attorney Yannetti the below screenshots of his or her text messages with Intermediary C regarding what Juror C revealed in the Zoom meeting. Intermediary C: no consideration for murder 2. Manslaughter started polling at 6-6, then ended deadlock at 4 no, 8 yes. That's interesting.
Yeah, no, that's a separate and apart from all this, but I guess if there's, anything for the DA to feel like not pathetic about themselves, maybe it's that. But I mean, this is destined to go one way. I mean, you can see where this is going long term, but I mean, that's now two of them that have emphatically said, we acquitted on the murder charge.
Right. And the third charge. Interesting. Informant C says, interesting. If it was no consideration for murder too, shouldn't she have been acquitted on that count and hung on the remaining chargers? That's what it says. Charges goes back to the jury verdict slip. That was all confusing. Intermediary C said she should have been acquitted. I agree. Yes, the remaining charges were what they hung on, and that instruction paper was very confusing.
But this is important too, because the way this works is you need evidence from like people with firsthand knowledge. The last two text messages are not from the juror.
Mm-hmm.
So those are going to have no real weight in like what the court does. But you also have, Jackson saying, I was told directly by a juror that we acquitted. And then you have an intermediary telling Yannetti that I was told directly by another juror, which is, I mean, that's also hearsay, but
Mm-hmm.
it should warrant further investigation to get sworn statements and or testimony from the jurors to see what they say.
Exactly.
They've certainly made a good faith basis for that inquiry at this point.
Yeah. Argument. This is the second section. The jury's unanimous conclusion that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes reprosecution. Quote, what constitutes an acquittal is not to be controlled by the form of the action in question, quoting Taylor. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense's charge. The mere presence or absence of check marks on a form is not dispositive. Here, the attached affidavits by Attorney Jackson and Yannetti reflect statements by 3 deliberating jurors that the jury had reached a final unanimous conclusion that Ms. Reed was not guilty on counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations. All right, then I quotes the affidavit. David Yannetti's affidavit, reflecting text message from juror B, it was not guilty on second degree. No one thought she hit him on purpose or even thought she hit him on purpose. To hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form would be to elevate form over substance in a manner prohibited by the foregoing U.S. Supreme Court and Supreme Judicial Court precedents. The Supreme Court's decision in Bluford is not to the contrary. There, a juror had reported during jury deliberations that the jury was unanimous against the charge of capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. The jury's deliberations had not yet concluded, and it went back to the jury room to deliberate further. Here, by contrast, the jurors' statements reflect a final determination that persisted through the end of deliberations. Even assuming arguendo and contrary to the foregoing, this court finds that retrial would not be prohibited under Bluford. This court can and should afford broader protection under Massachusetts state law. Citing Commonwealth v. Tinsley, which supports the proposition that unlike the U.S. Constitution, the Massachusetts Declaration of Rights does not include a double jeopardy clause, but our statutory and common law have long embraced the same principles and protections. B, reprosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was unanimously agreed. The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. And that's where that quote comes in, quoting U.S. v. Dinitz, which is a Supreme Court case. Yeah. Mm-hmm. Here, Ms. Reed did not consent to the declaration of a mistrial. See Alan Jackson's affidavit. Citing a case, Commonwealth v. Edwards, which stands for rejecting the argument that the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed. Absent the defendant's consent, state and federal double jeopardy protections bar, as a general rule, retrial of a defendant whose initial trial ends without a conviction. This rule is rooted in the importance to the defendant of being able once and for all to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. Accordingly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. Before a court declares a mistrial for manifest necessity, 1, counsel must have been given full opportunity to be heard, and 2, the trial judge must have given careful considerations to alternatives to a mistrial. Here, the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel, citing a litany of cases. The record is independently lacking on the second prong, as it reflects no careful consideration of alternatives to a mistrial. Here, there was one obvious alternative: to simply ask the jury to specify the charges on which it was deadlocked. Had the court done so and the jury articulated its verdict consistent with the statements of jurors A, B, and C, the double jeopardy implications would have been clear and decisive. Indeed, with virtual unanimity, the cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict.
This is like the most basic law 101 thing.
Mhm.
I mean, jury says we're hung, there were 3 charges, and it doesn't occur to the judge just to simply say, I want to make sure, is it on 1, 2, and 3 or some combination thereof?
Right.
And I mean, they say, Judge, we find her not guilty on the murder charge, maybe the lesser or the third charge, leaving the scene. And then the judge would say, okay, I'm entering judgments of acquittal as it relates to those counts. And then you would look at the DA and say, what do you want to do with regard to, the remaining count? And they would say whatever they want to do. It's interesting too, because sometimes that does influence not these prosecutors, because they are zombies, about what they want to do. But you get acquitted on 2 of 3, including the murder count. It's not inconceivable that they say we need to think about what we're doing here, instead of just coming out and saying we're going to retry her. Now, the reality is, if the count they were hung on was the second one, which is still a form of homicide, and they actually had a few votes, or even half the votes, then I don't think it would shock anyone that their initial reaction would be, we intend to retry her on that count. But, all of this narrative that was being spun publicly, the takeaway would be that if she gets acquitted on 2 of 3 counts, including the top count of murder, that this is not 100% victory for Karen Read, but about 95%. I mean, this is a hell of a lot more substantial than just they hung on everything.
Well, tell everybody what's circulating out there in the cesspool of Twitter, because so many of the viewers are not on Twitter and they might not even know what you are referring. So tell us. I'm not on there.
Well, you saw some of the usual suspects who are just rabble rousers and troublemakers running around, making up information, including one who self-identifies as a towel, if you know who that is.
Oh, yes, I do.
Claiming that, a source of a source, reported to him that it was 10-2 to convict. And the online sleuthing is unbelievable for some of, this army of supporters. It didn't take a genius, a very good person, long to find out that what the self-styled towel and self-styled journalist actually did was literally plagiarize a tweet from someone else with regard to another case, and just cite that as his source of a source. And then all these people ran with it, including the towel's mother, who purports to be a lawyer. The way I describe it is she has a law degree. There's a difference. Other online rabble rousers. And next thing you know, people like Court TV, some guy who used to write for the Boston Globe, other, self-styled and half-disgraced former radio show hosts are running around talking about 10-2, 10-2, and it takes on a life of itself.
Mm-hmm.
And, it doesn't make any sense. And then people who try to be reasonable say, until you hear from a juror, which is the kind of things that people like us would say, you don't know. what's going on. And then lo and behold, within a week, you kind of did hear from a juror, not directly, but these are lawyers of, high regard and high respect under penalties of perjury, saying what they heard, citing text messages and whatnot. You can be sure they have the text messages. You can be
Mm-hmm.
sure that they're not making this up. So that information was clearly all false. It could have been potentially used to prejudice Karen Reed at another trial because, again, it becomes news.
Mm-hmm.
And the good news for her is that news essentially gets wiped out by this, because this is remarkable what's happening here with this information.
And it was after those rumors started running rampant that Paul O'Keefe did his 2 interviews, right?
Yeah, and look,
Contemporaneous with anyway.
he did his interviews and whatever. I mean, I don't. That's fine. I mean, I think some of the things he said were a little cringe, not true, but whatever. He's also speaking as a family advocate.
Mm-hmm.
But it's also really interesting because he admitted, and there's nothing legally wrong with this, but he admitted that it was the O'Keefe family who invited the Brian Albert, McCabe, Colin Albert group
Yep.
to sit in court to,
Mm-hmm.
if you will, send a message that we don't believe they did anything. Now,
Right.
that's not misconduct. It's a free country. They're allowed to do that. But what's interesting is, and when you get to this, in Yannetti's affidavit, which I know you haven't gotten to yet, the jurors apparently have a group text. They're bonded, which is understandable with this experience. And apparently some of them, or at least one of them, is alluding to the fact that, what? It was intimidating to have Brian Albert sitting there scaring. Now, the interesting thing was
I knew it. I said that. I said
but
that day.
here's the weird thing. They referred to Albert as Higgins. So it's like frickin' frack. It's just like the two meatheads. They couldn't even keep them straight who they were. So, but obviously they meant Albert because he was there. But just to be clear, that's not an issue for this. And there's nothing that can be done about that. I mean, it's not misconduct to invite people in, even though it clearly appears to have had some effect on top of everything else.
I mean, it also sort of validates my intuition, because I did say that. I said, I don't know if that guy's he's looking at them. He was right in frame during Alan Jackson's entire closing on TV. And I'm like, he's looking right at them. We've been in that courtroom. It's very small. He's not that far away from them. And they could have felt intimidated by him and his facial expressions. And he was mouthing things under his breath. And he looked like he was about to bust out of his collar at certain parts.
But
there's me, and I was sitting at home.
I mean, when you start hearing them referring to that there is a group text, I mean, look, if a woman was acquitted of murder, the court is obligated, and there are credible allegations that happened. You can't just ignore that. You have to allow some evidence to be presented. And now, in addition to possibly having jurors testify, in addition to having Jackson and Yannetti probably testify, in addition to possibly having the judge testify because she had that private meeting with them. A juror text chain, my God. I mean, what could be contained in there?
Yeah. And it's just the whole case. There were so many group text messages and the evidence too, that this is insane. Let's keep going. So we get to the good stuff. As if this is not already good enough.
At 1:05, I'm going to jump off for 10 minutes. I told
sure.
Grace Curley I would talk to her on WRKO for a few minutes.
Oh, all right. Well, don't tell everyone that, because then they're going to leave here to go listen to you.
Okay.
You can. I don't know what WRKO is, but
it's Boston radio. Anyway, I have 10 minutes, then I'll come back.
That's okay, because I'm just going to read through it and you've already read it. The Supreme Judicial Court SJC is holding in Commonwealth v. Roth that courts should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. As the Roth court acknowledged, inquiry concerning partial verdicts on lesser included offenses that have not been separately charged carries a significant potential for coercion.
Yeah, it's a big distinction. That's what I was trying to allude to earlier, that it's not like you have one count under which you could find lesser elements create a lesser included offense. These are three separately charged offenses, and they were instructed, if you recall, only because Jackson complained about it in advance, to make sure that it's clear that they deliberate each. So yeah, the fact that nobody would say, well, you're saying you're hung on one count, but did you consider the lesser included offenses that are built into that count? That would be implying maybe you can find her guilty of something. But that's totally different than this, where they're told there are three and they're supposed to do all these three. So that language isn't going to help them.
And remember, he complained about that verdict sheet. I don't know if you were with me when we went over it, and she dismissed him. This is the way we do it in Massachusetts. And then after she had her little timeout, she came back and reversed herself and said, but I want, I want it on the record that the first verdict slip was proper.
That is going to come back and bite her, because people now have a really dim view of what happened here. And all of a sudden, how do you avert your eyes to that spectacle that occurred, where it's what I call the forget it, Jake, it's Chinatown speech again, for like the 10th time in this case, that listen, Hollywood guys, sit down. Here's how we do it here. And it, in some ways he was prescient about some of the concerns that could happen here. And the doomsday scenario has apparently happened for the judge. It happened exactly what they were potentially worried about happened. And how foolish do you look now that you were so dismissive, yet you did agree ultimately that he was right. And this is the same issue, by the way, that you yelled at her, Karen, made front page news when she was allegedly smiling and smirking.
Something funny, Ms. Reed?
Because what I would suggest in hindsight, what might have been funny is like, what's going on here? This is ridiculous. And you know what? Look what's happening. It is ridiculous. They were right.
They were right.
They were right.
This footnote says Massachusetts law, to the contrary, clearly permitted the jury to return a partial verdict on some, but not all counts.
It would be unconstitutional. I mean, good for Massachusetts law, but this is black letter double jeopardy stuff. You can't say all or nothing on every count. You're hung or not. I mean, a defendant has a right to be judged on every count. And if a jury wants to acquit on certain counts, the defendant has every right to benefit from that. I mean, it
seems so obvious, right?
So obvious to us, but when you finish the motion and I come back too, it'll be interesting to discuss logistically what happens next, because this is going to be interesting in terms of the actual mechanics of what they do to establish, what they're going to argue here.
Yeah. All right. So here they say such inquiry in effect implies that the jury should consider conviction on the lesser count. No similar danger is present, whereas here the jury was asked to return 3 separate verdicts on 3 separate counts. And we talked about this. There were 3 separate pages to this, 3 separate pages that they had to fill out. In this circumstance where the jury reports a deadlock without specifying the counts on which it had reached an impasse, it is a straightforward, and the defense contends constitutionally required, follow-up to ask whether the deadlock relates to some as opposed to all counts. Indeed, the SJC has explicitly stated, where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts, despite deadlock on the other counts. Well, there you go. There's the Massachusetts law right there.
Here's what's scary is that, obviously that's the law of Massachusetts, and that's the law everywhere, and that's the law of the United States Constitution, because it's basic fundamental fairness, and that it even needs to be stated that that's the case in a murder case of this magnitude in front of a judge that's been, a judge for that long. And in light of all the issues, that it was the second note coming back saying we're hopelessly deadlocked, and to not make an inquiry or do anything. She
strains credulity, my friend. It strains credulity.
I think the
defense was looking around like, okay, like, is that it? Alternatively, yeah. You're even speechless today, Mark. I've been made speechless.
This is a terrible look, and I'll tell you, if I'm the defense, I'm saying, Your Honor, we know you had a meeting with the jurors, and we need you to testify, because I'm using this as a way to get her off the case, no matter what. I'm getting her off, and this is the ticket right here.
Yep. Here's the ticket. That's the ticket. What's that from? That's the ticket.
Oh God, some Saturday Night Live thing.
Saturday Night Live, yeah.
100 years ago.
Alternatively, the defense is at least entitled to conduct post-verdict inquiry. To
All right,
conduct.
I'm going to jump off and then come right back.
All right, go.
Okay,
I'm reading, so you won't miss it. You've already read it.
Okay.
Okay. C, alternatively, the defense is at least entitled to conduct post-verdict inquiry. Undersigned counsel did not initiate the communication with jurors A, B, and C, which resulted in the disclosure of information that is memorialized in counsel's affidavits that are appended to this motion. Should this court find that further factual development is required, the defense respectfully requests that the court conduct a voir dire of the jury and/or an evidentiary hearing to substantiate the existence of an acquittal. Should the court seek the affidavit of each juror, i.e., jurors A, B, and C, the defendant asks for the court to authorize the undersigned counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed that the defendant was not guilty of counts 1 and 3. The SJC has held that because of the importance of the case, the importance of the issue, juror bias is legitimate subject for post-verdict inquiry. So they're trying to get around that law that Mark was talking about that does not allow attorneys to contact jurors by telling them it's for a very limited purpose. It is similarly a fundamental tenet of our system of justice that a defendant may not be retried for a crime on which she was previously acquitted by a jury, and the defense submits that post-verdict inquiry is equally warranted in the present context. Just as the court and in McCallop approved questions as to the existence of a racial bias, questions about a matter more attenuated from the content of deliberations, whether the jury had unanimously concluded that Ms. Reed was not guilty of counts 1 and 3, do not invade the heartland of jury deliberations, but preserve the defendant's precious rights to the favorable outcome of a jury trial and to the protections of the Double Jeopardy Clause and its related state judicial protections. Conclusion. For the foregoing reasons, Ms. Reed respectfully requests that this honorable court issue an order dismissing counts 1 and 3. And this is actually signed by David Yannetti, Alan Jackson, and Martin Weinberg. Martin Weinberg filed a notice of appearance today as well, and I think it was for a limited purpose. I haven't seen that notice of appearance, so I can't read that to you. But Martin Weinberg is the new attorney that's coming in. Here is the affidavit of Alan Jackson. And here we go. This was filed this morning, 9:02 a.m. Took a little while to hit the airwaves. Affidavit of Alan Jackson in support of defendant's motion to dismiss. I, Alan Jackson, declare. 1, I'm a partner at the Los Angeles law firm of Worksman, Jackson and Quinn, LLP, and I have been licensed to practice law since 1994. I am counsel for Karen Reed, appearing on her behalf in the Commonwealth of Massachusetts pro hoc vice. On Tuesday, July 2nd, 2024, I was contacted by Juror A, true name and identity withheld to maintain anonymity. Anonymity. Based on my conversation with Juror A and that juror's description of who he or she is, where he or she was seated, and certain identifying information, name and occupation, disclosed during the voir dire process, I was able to positively identify which juror he or she was. Juror A told me that he or she was seeking inaccurate. Juror A told me that he or she was seeing inaccurate reports about the split among the jurors related to the mistrial that the court declared the day before. Juror A stated that he or she wished to be respectful of the privacy of the deliberative process, but did wish to inform me of the true results of such process. Juror A indicated that he or she believes it is important to disclose such results because he or she believes that those results significantly impact Ms. Reed's rights. 5, Juror A told me that the result of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder, was off the table and that all 12 of the jurors were in agreement that she was not guilty of such crime. Juror A told me that shortly following that determination regarding count 1, the jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury or death. On July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. Neither Ms. Reed nor her counsel consented to the entry of the mistrial. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, and on which count or counts the jury may have arrived at the verdict. Nor did the count on its own inquire of the jury foreperson on which counts the jury was at an impasse and whether the jury could or did reach unanimous agreement on any of the other counts. Had the court so inquired, it appears that not guilty verdicts would have been recorded for count 1 and count 3. Ms. Reed was denied her right to receive those verdicts in her favor. Foregoing is true and correct to the best of my knowledge and belief under penalty of perjury under the laws of the United States and the state of California and the Commonwealth of Massachusetts. Signed in Los Angeles, July 3rd, by Alan Jackson. Moving on to David Yanetti's affidavit. You guys, this is so explosive. Like, you don't even know how explosive this is. It's crazy. Get rid of this. Yanetti's affidavit filed this morning, 9:07 a.m. Affidavit of David Yannetti in support of defendant's motion to dismiss. I, David Yannetti, do hereby depose and state that the following is true to the best of my knowledge and belief. I am an attorney licensed in Massachusetts since December 20th, 1989. My main office address is 44 School Street, and gives his address. On January 29th, 2022, I was retained to represent the defendant Karen Reed regarding the above captioned matter. Well, that answers some of our questions because he was retained on the same day of the murder of Officer John O'Keefe, the same day that her car was towed from her parents' house in Dighton. She was immediately represented by counsel, and rightly so. If somebody came and towed your car, and remember, he had a personal phone call with her before he got there to tow her car on his personal phone. And we don't know what happened during that call. On July 3rd, 2024, I received communications from two different individuals, hereinafter Informant B and Informant C, who had received information from two distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. To my knowledge, Informant B and Informant C do not know each other. On July 3rd, 2024, Informant B sent me a screenshot he or she had received from someone, hereinafter Intermediary B, of text messages that Intermediary B had received from Juror B. In that screenshot, Juror B texted the following to Intermediary B, quote, "It was not guilty on second degree and split in half for the second charge. When the judge sent us back with that Hernandez thing to look at, the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose." And that's the way it was written. "They gave us free counseling forms when we left." Okay. Okay. Wait, I'm going to break from the document and say free counseling forms, like counseling, like they should go see a therapist. When he says Hernandez thing, I am assuming that he's referring to the Tui Rodriguez instruction that was given to them. That was after the second note when they said they were deadlocked. And it's sort of like a pep speech, like, come on, you can do it. No other jury is going to be able to do this better than you. Get back there and try and understand other people's positions. And this juror said in his text message to the intermediary, It turned into a bully match after the judge read that instruction. Based on the first name of juror B given to me by informant B, I believe I am able to positively identify which juror he or she was and confirm that he or she was a deliberating juror. On July 3rd of 2024, informant C contacted me to say that he or she personally knows juror C as they used to work together. Informant C and juror C also have a mutual friend, hereinafter intermediary C, who is a current coworker and friend of juror C. Informant C told me that he or she had posted something about the Karen Reed case on Facebook on Monday, July 1st, 2024. He or she told me that he or she believes that post led intermediary C to text him or her and inform him or her that juror C was a deliberating juror on the case. Informant C told me that he or she thereafter reached out to juror C via text message and discussed his or her experience as a juror in very general terms. They discussed what an exhausting experience it was and that juror C was relieved that it was finally over. Intermediary C told informant C that juror C would be participating in a Zoom meeting with a number of friends to discuss what happened with the trial. Today, informant C sent me 3 screenshots of a text message exchange he or she had with intermediary C. Informant C told me that intermediary C was reporting to him or her during this exchange what juror C had revealed during the Zoom meeting. The text message exchange reads as follows. Intermediary C, quote, no consideration for murder 2. Manslaughter started polling at 6-6, then ended deadlock at 4 no, 8 yes. He or she was very consistent in the fact that they could only consider things that were admitted into evidence. Ultimately, he or she voted no because the cause of death was twofold of hypothermia and head injury, of which he or she was convinced that the vehicle did not cause both. The whole jury felt very intimidated by Higgins' presence at the end. I think that's what Mark was referring to before, that perhaps this juror mislabeled Brian Albert as Higgins because it was Brian Albert that was in the courtroom sitting behind Alan Jackson and David Yannetti and looking straight at the jurors while they were doing their closings. He or she is not sure what he or she's going to do. He or she's going to lay low for a couple of days and see where it takes him or her. Hasn't ruled out anything. The jurors all have a group text going. Informant C then wrote back, interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip. That was all confusing. Intermediary C replies, she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. Informant C replies, what a great experience for him or her. Amazing that they it should say Alberts. Amazing that they let the Alberts in the last day. Intermediary C replies, he or she felt very honored to be part of it. He or she was, and then it says redacted physical description of juror C. Everybody else was from a professional walk of life. They all got along and never heated. They agreed to disagree and respected each other. Well, that's nice to know. Informant C, that's the way it should be. I knew it was an intelligent jury. They will be studying this case in law programs for years to come, i.e., how not to investigate and try a case. If they all agreed on no for murder 2, they should make that clear to the DA and the court. It's basically a case of double jeopardy if she is retried on that charge. Next paragraph of David's affidavit. Based upon the description of juror C given to me by informant C and confirmed by the redacted content of the above text message exchange, I am able to positively identify which juror he or she was and confirm that he or she was a deliberating juror. Signed under the pains and penalties of perjury, the 6th day of July, 2024. Here we are, my friends. Here we are. Information from 3 jurors indicating that the jury unanimously decided to acquit on the murder charge and the 3rd charge of leaving the scene of the accident. And the judge never asked. Mark had to step out for a minute. He's going to come back. I'm going to say hello to some peeps. Melly, happy Monday. A beautiful, amazing Melanie and amazing Mark. Beautiful Melanie and amazing Mark. Thanks, Melly, for your super chat. Brooklyn James, thank you for jumping right on right away to discuss this. Oh, we couldn't. I was racing home in my car. Like, I got to pull over and schedule this live. We got to do it now. So I'm so glad that Mark reached out. Thanks, Brooklyn James. Mrs. Bucket, thank you for your super sticker. Blessed Mom from Texas, how are you, my dear? Melanie, love you, bestie. Thanks, Mark, for all this. Melanie, I'll send an email. Love to cupcakes. Thank you, Blessed Mom in Texas, for the 10. On top, for being on top with the super sticker. Thank you so much. Nancy Rock, thank you for the 10. Thank you for covering. I feel they did not understand the verdict form. Right. We went over this. We went over the entire verdict slip together. I told you my thoughts. I told you my thoughts when she said she was not going to amend it based on Alan Jackson's argument, which was a very good one. This is the way it's always been done in Massachusetts. And then she said to David Yannetti, right, Mr. Yannetti, you've seen it done this way before. And he said, no, actually, Judge, I haven't. And she said, oh, you've never had a case with lesser includeds before? And he said, well, yeah, I have, but I've never seen it like this. I've always seen a guilty box and a not guilty box. So there's that. I agree, Nancy. Not only the verdict form, but the jury instructions were also very complicated. Oh, thanks, Adam Drives Helen, for the 5 added to the Cupcake Fund. Thank you so much. Brass, thank you for the 5. Judge Cannoni allowed a mistrial in a similar way for the murder of Sergeant Michael Chesna less than 2 years ago. Would both mistrials cause her forced recusal? No, I do not believe so. Every case stands on its own, and a mistrial is a mistrial. It's not always the judge's, fault, and judges have judicial immunity, so I don't think so. Wildflower 347, thanks for the super chat. So we going to we going with Auntie Bev is corrupt? We can ask Mark that question when he comes back. I'm not going to go that far. Negligent, perhaps, and not asking the jury their split. We don't know what that private conversation was, and I thought it was odd when she said to the jury, "Okay, you can go now. I'm not going to make you go back and deliberate, but I will come in and talk to you privately. You can leave." But judges sometimes do that, to go back and thank them, because she was not overly thankful during that speech in open court, thanking them for their time, their service, there was going into the 10th week, this trial. CamVat1, thank you for the super chat. If Bev denies the motion, can they appeal? Yep. Who knows how long that would take? Polo keeps. Thank you for the eyes. We are the eyes of the world. Remember that. The world is watching. Sussex Sandra. Auntie Bev, that's your opinion. My opinions of my viewers are not mine. Please, that Auntie Bev is corrupt. She's the only one who insisted on moral certainty. Where was her morality? Moral certainty is part of the jury instructions in Massachusetts. We have learned throughout this trial. And so that's what they say. Here he comes.
Hello. Good.
How was your interview? It was good.
It was fun. It was, it's always interesting. And to me, what we were talking about mostly was, the defense calls the Honorable Beverly Cannoni as a witness, potentially.
Yeah. So we read everything, which you have already seen. So are there any further comments on the papers that you would like to make?
It's fascinating. It's detailed. They appear to have text messages. There's a lot of quotation marks, which when you do legal writing for a living, as I know you will agree, there's a reason why a lot of this stuff is in quotation marks. The Brian Albert, Higgins, whatever you want to call it, thing was interesting, although to me it's legally meaningless. I don't know how you do anything here other than grant them the ability to gather more evidence, submit it, and then I think you have to have a hearing. I mean, you can't do anything that could potentially allow an acquitted defendant be retried and then potentially convicted. I know that would never happen, but convicted for murder. I mean, you couldn't have a worse violation of somebody's constitutional rights than to be tried twice for murder after being acquitted the first time. You have to let this play out. You have to let them gather evidence. You have to let them present the evidence. And you listen, if the jurors are wishy-washy and it doesn't go anywhere, then it doesn't go anywhere. But how do you just not if they can get their ducks in a row, and get the proper evidence before the court, grant them an evidentiary hearing on that.
Well, they've got a date set for July 22nd, so potentially they could do it then, but I kind of think it needs to be done before that. Unless she's going to turn that date into this.
I wouldn't even be surprised if she did nothing until that date and said, okay, what are the next steps? I mean, look, I think she ought to be accelerating the timeline. I agree. She probably won't, but it's summer, you know.
Yeah, summer hours.
So it's nice out, and courts generally don't do much in the summer. Neither do lawyers. Court, for what it's worth, that is true, or we do less in court. But ultimately, you have to let this play out. But there's no reason she couldn't grant an order ASAP, allowing the taking of more evidence, and why not gather, if jurors are willing to talk, affidavits, if they're willing to share this text chain. You can redact their names so no one's made public. That could be part of the order. I mean, you could see the lawyers are calling them juror A, B, C. You could go down the line with that, but ultimately they ought to get affidavits from the jurors, or be allowed to, because that will let you know how real or not real is this. I mean, interesting question is this. Is there any reason to believe that at a minimum 12 out of 12 jurors, if they were forced to testify or give statements, would disagree on what happened on the murder count? I mean, it seems kind of likely they wouldn't, in light of how emphatic these three are. I don't know. But I mean, and if you're the DA, wouldn't you want this resolved as well?
You would think,
right? I think they'd be doing the DA a favor if they just punted the murder case anyway. It would shorten the case, and the case was overtried anyway, and it would just be forcing their hand to do this, if they're really going to do it again, in a much more organized, less, you don't need 75 witnesses kind of way. But mess. Just a mess.
Interesting how I think it was Jackson asked the court for permission to contact the jurors for the limited purpose of just finding out if this was accurate. And I wonder if she will grant that. Because you said, is it a court rule that the attorneys are not allowed to contact the jurors after the trial, or is that?
I think it's a Massachusetts thing where you're not allowed to, but obviously, how do you not allow in this instance that? Now, what I'm wondering is if there's a motion also coming asking that this be held in front of another judge, because your honor is potentially a witness. I mean, could that be coming in the next wave of papers? And again, with an eye on the long game, to kind of get her under an appearance of conflict, if nothing else, out of the next trial, if there really is one, which I don't think there will be, but there could be.
Well, we didn't think this one was really going to go ahead either. So here we sit.
But I mean, if she's a witness, then you would have to have this hearing in front of another judge.
Exactly.
And if there's this conversation that we know she had with the jurors, somebody needs to explain what that was. Now, there's a good chance that conversation was nothing other than, thank you for your service. I know this was like a painful 2 months, emotional. And I mean, I don't think they were going to be talking about the verdict, I don't think the judge would be doing that with them, but you don't know. And you don't know what the jurors are going to say. You don't know what the judge would say. You don't know anything. All you know is that the two lawyers have sworn, under oath, essentially, that there's 3 jurors who contacted us separately and individually without communicating with the other ones, allegedly, that this happened. Now, there's a juror chat, we're told. Did they discuss it in chat? You don't know. Did they say, oh, I'm going to call, you should too, let's all tell the lawyers no? We don't know. But at least at this point, what you do know is that you have 2 very credible lawyers alleging that this happened, and it certainly warrants more investigation, because you could be subjecting an innocent woman to getting tried for the same crime twice, which is,
she could call all 12 of the jurors in to be interviewed or questioned in camera and have everything on the record and ask them questions. It wouldn't be an open court, obviously, because these jurors can't be doxxed. Unless.
I don't know how you couldn't. And by the way, if you were the DA, I don't know why you wouldn't want that, under the hope that maybe I can get one of 12 who says that's BS and then make an argument. So it seems to me it's in everyone's interest, including, frankly, the credibility of the entire Massachusetts criminal justice system, in light of this latest, I mean, I was just telling, Grace, the only this is so crazy that, today they're taking the next step towards the termination of a corrupt misogynist investigator, and it's like blown off the front page just on this case. It's become like, not even a big story because of this.
Yeah, Proctor has a hearing today.
Yeah, no, his next
Yeah.
step towards his termination is today, and all of a sudden that's just swallowed up by this. I mean, this is a much bigger deal than that.
Yeah, well, we can cover that one later because we're coming. Oh, Duncan, Idaho, thank you for your super chat. This seems as close as possible to plausibly deniable judicial misconduct to me, or gross incompetence,
What?
right? Was she on vacation at that point and in a rush to get out the door?
I want to be careful. There's no evidence based on these allegations of what I would call judicial misconduct or anything intentional or however not taking responsibility when the jury clearly was struggling with reaching a determinative outcome to fill out a complete verdict and never once trying to determine what that meant on 1 count, 2 counts, or 3 counts. Ultimately, the judge is responsible for the courtroom. She's responsible for making a clean record. She's responsible for protecting the defendant's rights. She's responsible to making sure everything, all the I's are dotted, all the T's are crossed. And for some inexplicable reason, she never inquired about that, never shared the note apparently with the defense, according to these papers, never gave them the opportunity to be heard. Perhaps if they were given the opportunity to be heard, one of the lawyers could have stood up and say, well, Judge, how many counts? How do we know what's going on here? So she screwed up in that regard, but that does not literally translate to corruption. But what I do think it does is it puts her as a witness in this hearing, potentially, which is going to jeopardize her ability to sit over the second trial.
Yeah, negligent, but not criminal, perhaps, what she did. Obviously, judges have immunity. So people were asking, like, does the fact that this is her second big mistrial in a year, is that grounds for getting her kicked out? No, they're appointed. They're appointed in Massachusetts, the judges. So they were not elected. They're not elected like they are here.
It's funny because last week somebody said the same thing. Oh, 2 mistrials. How does that weigh against her? And well, it doesn't. She's just a judge. The interesting thing here is that this complete mistrial, which is what it is right now, could be her fault for failing to, ask the right questions about the various charges. I guess we'll have to wait and see to what the evidence comes out to. But look, when the verdict sheet was being discussed, I mean, I was one of the people talking about it even then, saying, well, how do we know? What if there's a split verdict? And it happened. And when the actual mistrial was declared, I remember the two of us and others also saying, oh, well, what's the mistrial on? How do we know? And then just kind of accepting, well, I guess it's for everything since she's not saying anything. And, that doesn't appear to be the case, at least today. And I mean, this is just a terrible look for everyone involved in this, particularly the judge.
Yeah. Brenda says, let's celebrate with gratitude. This is the sunlight we've been praying for. So grateful to have found you two who demonstrate integrity and courage. Let's get these bleep bleeps. Oh, well, if you listen to the cesspool, we have zero integrity, Mark, but thank you for recognizing our integrity because we believe we do. Cat's Pajamas, thanks for tuning in from Canada and for your super chat. If the judge denies a voir dire or evidentiary hearing, can another impartial judge be brought in to make the determination due to potential bias or improper interpretation of the law by Judge Cannoni?
Well, I think what would happen is they would have, a basis for appealing that, I mean, they're going to make a post verdict, even though there's no verdict motion. What in New York you would call like a 440-10 or 330-30 motion, just a post conviction, although there's no conviction here, motion type thing. And if it gets denied without a hearing, that would be something that could certainly be appealable. I don't see how she's not going to have any choice other than, at a minimum, allowing more evidence to develop this issue. I mean, you have 2 lawyers swearing under oath, this is what happened. You can't dismiss that out of turn and just say that means nothing, even though there's no question the law does not favor asking jurors questions or having them testify. I mean, that they're like the most protected people in the whole process. But the interesting thing here is, according to the lawyers, they are the ones who stepped forward, who started and initiated this process. Three of them,
Right.
that's 25% of the deliberating jury,
Yep.
was offended enough to say, oh my God. So I don't know how you can ignore this.
Oh,
You
you
can't.
absolutely can't ignore it. And if she does ignore it and say, no, I'm not going to do anything, that's immediately appealable, I would
If
imagine. And
she, yeah, and also the scandal factor will increase exponentially because you can't just bury your head in the sand with these kinds of allegations. I mean, potentially the DA, I mean, look at them. They are zombies. I'm sorry. You can't keep them down. They just keep coming. You can't shame them. They'll do whatever they want. Do you really think that if the ultimate decision here is I'm going to just deny this without a hearing and I declare a mistrial on all charges, do you really think that the Norfolk DA will not say, okay, then we're going to try her on murder? They will, because they're zombies.
yeah. Zombies. Resistant to silence. Thanks for coming in. Lots of news out there, but just a reminder, we will be at MSP Barracks at 4 p.m. protesting the actions of Proctor and his bosses. Thanks for the 10. And I guess, Mark, you going to drive up for that?
No.
You can still get there. Probably. No, you probably can't. It's already
Well,
1:30.
it is in Framingham, the town I'm from. So it's,
You
it's
could
nice,
visit some relatives.
right by the state police headquarters. No, not this time. I'm staying away from that.
Can you please describe, somebody said, could you please discuss Massachusetts? Thanks, reality check. Could you please discuss Massachusetts law on tampering intimidation?
Well, I
They
think it's
have a weird, wacky, and witness intimidation statute. You
okay.
familiar
But
with
I
it?
mean, yeah, I mean, I'm familiar with it in the sense that I looked it up during, Turtle Boy had his arrest or whatever. But if this relates to the jury thing, there's nothing inappropriate in a legal sense because three citizens were invited by the O'Keefe family to sit there. It may be unseemly, it may be gross, it may be any number of things, but it's not illegal or anything. And the fact that the jury or juror, at least one juror, felt intimidated doesn't mean that the O'Keefes did anything wrong in that regard in a legal sense. There's no remedy for that. That I wouldn't even waste thinking about that.
Yeah, and but in the same vein, reality check's first message was curious if Paul O'Keefe might be guilty of intimidation. I mean, the way he was glaring at Karen. Well, apparently, the witness intimidation statute. I mean, the stuff that Aiden's being charged with is like the way he explains it or has explained it is that if you hurt somebody's feelings, that's enough for witness intimidation.
Well,
I haven't read the statute. You
yeah,
have, so
the case against him is problematic because he is, whatever you think of him or not, he's acting in a journalistic capacity, and to, as I like to say, die on the hill of prosecuting a journalist because Jen McCabe's feelings were hurt, and Michael Proctor is one of the quote unquote victims in that case. I mean, the irony, okay,
right,
of
right,
Michael Proctor, who, look what he said about Karen Reed, and look what he did. Now, granted, she didn't know in real time. I get it. But the fact that he's a victim of harassment, or Buchanan claims that he was a victim of harassment, and Brian Albert, I mean, this is ridiculous. So,
right.
but
They're afraid of him.
no, it's a joke. And then they all came running at him when he was in Canton a few weeks ago, whatever. But they're not arresting Paul O'Keefe because he was looking at Karen Reed in the courtroom. It's not, I mean, I wouldn't.
Yeah, or because he orchestrated the presence of Colin Albert, Brian Albert, Jen McCabe, and Kerry Roberts.
Look,
They're allowed to do that.
they're allowed to do it. His brother was killed. He seems to be misguided on a lot of things. He did make a lot of statements that are really, as we said, cringe, some of which are just not true, some of which are just, defending Proctor's private messages. I mean, you just kind of want to ew, but I mean, he thinks his brother was killed, and he's been told this story for years. I don't think coming after him does anyone.
No. I mean, grief is a strange thing, and I, hate to judge someone for their grief responses, just like the way people are still judging Karen for her grief responses,
right.
Of how she, the way Paul O'Keefe said in his interview, she just went upstairs and took her stuff and left, and that's when we knew she was guilty.
Well, yeah, I mean, again, that was kind of silly, but I don't think it's worth micromanaging what he's doing or what he says to the press. It doesn't matter.
Yeah. Dagnabbit says, might the judge just grant the motion to dismiss counts 1 and 3 rather than publicize the embarrassment to herself and the Commonwealth?
She
I don't think she
can't.
can
I
do that.
mean,
No.
first of all, the DA has a right to be heard as well and have a position. Now, if they want to surprise people and say we consent to that, even then the judge would have to have a factual basis to do it beyond an affidavit from a lawyer. I mean, even if everyone agrees, judges can't just change verdicts or non-verdicts based upon a sworn affirmation from a lawyer. There has to be a factual basis to do it. So I don't know how you need the real evidence. The real evidence is not an affirmation from Cameron
Right.
Reed's. The real evidence is sworn testimony subject to cross-examination by jurors and the lawyers and whatever. So nothing's going to change unless there's some like actual evidence to support it.
And especially based on the fact that two of those sources is like double hearsay. So
Yeah,
the
I mean
judge would
both.
need to hear from the actual jurors.
Right. Absolutely. I mean, both the lawyers, again, I don't think anyone other than the online trolls who thinks that these lawyers are like these unethical losers when they're the exact opposite of that. But I don't think any sane person thinks that lawyers of this magnitude are just submitting false affidavits. So I
No.
don't have any reason to doubt what they're saying, but it's not admissible evidence. I mean, it's still hearsay.
A lot of people out there who believe that, like Karen Reed should just be burned at the stake, or, they're lying in their affidavits. I'm sure that's coming next. Like, they're lying. Okay, you don't understand
I'm sure they're
as an
lying, and
officer of the court
and I'm
how
sure
you
I'm
cannot
I'm
perjure
sure she
yourself in an
told him
affidavit.
to do it, and I'm sure she told him to do it
Mhm.
while she was smirking and, talking about how I'm enjoying all of this. I mean, look, their views of her are ridiculous. Apparently, they believe that the way she should conduct herself on trial is to have a perma upset, stare at the floor, and rock back and forth and apologize out loud when your position is I'm not guilty. I
Mhm.
mean, her position is
Exactly.
I'm innocent. So, but I mean, they're always going to criticize her for the way she does anything. They just seem to have this irrational hatred of everything about her for some reason. It's
Yeah.
weird.
Somebody sent me something, some streamer who had like maybe 200 people watching, was talking in their stream about how Melanie Little has been fired by the defense team. I'm like, I was never hired, but what do you like the
Everyone's a PR.
insanity? She's been let go. Yeah.
Anybody who has like some level of intelligence in anything about this and believes that she's not guilty or innocent and is willing to say that apparently is on the payroll. That's just the way these people work.
Yeah.
It's
It's impossible that anybody could have an independent opinion.
you're not allowed to have an opinion.
Sean O'Keefe was not hit by a car. It's impossible to have that opinion. You must be getting paid or you're stupid. That's what they say. Mary, thank you for your super chat. If she's not guilty of murder and not guilty of leaving the scene, then what is she guilty of?
Well, apparently, possibly, according to the jury, as we now are led to believe, possibly manslaughter. So, in order to get to that intellectually, you'd have to agree, as crazy as this is, that they were willing to accept the car accident, that she did strike him and did cause the injuries that ultimately led to her death. Instead of intending to do it, they would be buying into the intoxication part of this. But I would still be optimistic if I were the defense, even on that charge, because ultimately, if they do have to deal with that charge and that charge alone, the feds are going to let them talk to the ARCA witnesses the next time. They're going to release that protective order. They're going to prep them. They're going to probably, I mean, look at these unbelievable presentations they put online through their tech guys. And I'm sure that they will do some of that. And again, today is a really, really good day for the Karen Reed team, like really good. And it
Really
also
good.
wipes out this really misguided and, let's be honest, dishonest nonsense that she was hanging by a thread and is lucky that she got um, you know got a hung jury and was hanging by the skin of her teeth, according to some of the rabble rousers, and that just appears to be completely and unequivocally not true.
Agreed. I was looking for in Yannetti's affidavit, he said something about during this group text that there was something about when we got that he said Hernandez, but the Tui Rodriguez instruction, that's when all hell
Right.
started to break loose, because she told us to listen to other people's viewpoints, and then everything broke loose after that. So that was an interesting little tidbit.
Yeah, I don't understand that. I mean, I don't understand why saying you should listen to other people's opinion is earth shattering. I mean, you should. It doesn't mean you have to change yours, but I don't know why that would be upsetting to just say,
Yeah.
try to reach a verdict. So let them make their case to you. If it's convincing, good. If it's not, it's not.
Thanks, Millie. I think we just covered this. Can you either explain what the not guilty on 1 and 3 and many voting guilty on 2? Thanks for the great coverage. We don't know what they were thinking, but
That's the kind of stuff that just makes you, and I hate to do this again,
right.
but I have been an advocate of a bench trial in this case
Oh,
because
I know you have.
the reasonable doubt is open and shut. And it's not that I don't believe in juries, but when I see what the potential, she could have been 6-6 or even 8-4 against on the second count, but the other two are not guilty. And now you're talking about potentially this judge getting booted off the case. This is a bench trial.
Yep. Yep. Agreed. I mean, with a different judge, though, not with this
Yeah,
judge. So yeah, if they get her off, then
I don't know how she's going to be able to stay on if she becomes a witness in this. I mean, I think that would just be a terrible look.
yeah. I mean, I thought that in the Murdoch case too. I don't know if you followed Murdoch, but it was the
Little
same
bit.
sort of thing where the judge became a witness, Judge Newman, because he had certain conversations with a juror and the clerk, and then they did appoint a special judge to, I think, hear the ruling to hear that motion about the egg lady juror. So we're going into a different case now that you may not be familiar with.
Not that familiar, but I mean, the problem is that the judge here theoretically could be a fact witness on relevant issues that relate to the juror's credibility, and she could be getting vigorously cross-examined by a lawyer, not Jackson or Yannetti, but I forget his name, but he's highly, highly credentialed lawyer, the new one who joined the team for this purpose. But it's still Karen Reed cross-examining the judge. And don't forget, since the last time when they asked her to recuse herself, what else has happened? The judge snapped at Karen Reed, got her on the front page of the paper. There is every reason imaginable, if there's a retrial, for the judge to just walk away, because ultimately you have to have an appearance of fairness, and it's getting too close to home here.
Yes, agreed. Thanks, Shaylee, for your comment. I appreciate you. ALL, thanks for the 10. Wasn't Judge Bev the one who added the manslaughter charge as an option? I know she added something that neither the defense nor the prosecution had agreed upon.
No, they were all indicted. I mean, ultimately, they were all indicted charges by the DA. So, I mean, there are things to blame the judge for, not making clear what counts were acquitted or not, or hung is one of them.
Right.
But blaming her for the actual, charges in the indictment or that went to the verdict sheet, that's not her fault.
Yeah, the manslaughter charge there was an indictment on that, so that's why that was included. Susan Vaughn, thank you so much for the $20 super sticker, and Phoebe Bird for the $10 super sticker. You guys are amazing. Karen says, if they have to drop the murder charge, does the DA have to change their theory of it being intentional?
Well, yeah. I mean, in the sense
Right.
that that charge would be gone, but that's why we also said they overcharge this. I mean, as a prosecutor, you want to be credible and you want to connect with the jury and look credible. And honestly, trying a case where you say, well, she intended to do it, but if she didn't intend to do it, she recklessly did it. And if she didn't recklessly do it, then it's just not credible. They should have latched on to a credible theory and gone with it. And by charging intentional, look what it made them do. It made them go with this just ridiculous idea that, because of what happened in Aruba and jealousy and text messages. I mean, that's just nonsense. And if they had cut that crap out, they would have probably wiped out a week of trial, at least all these dumb witnesses that they didn't need, these stupid text messages, which did not help them. This stupid stuff about witnesses from Aruba, and just say, look, She mowed him down because, I mean, look, if you're going to try the case, you say she's wasted, okay?
Mhm.
Backed into him and then just freaked out and said, in a selfish fit of whatever, I'm out of here. And if you want to say she's cold hearted, I don't think this is a very credible theory either, but in light of the evidence, but that's a better theory than she just, after canoodling with him at the bar all night, got pissed off, left 50 messages, and decided to mow him down, knowing that all these people were in the house waiting for us. I mean, think
Yeah.
how stupid that is. I'm
Mhm.
driving him to a house. They're all inside, but I'm just going to gun it on purpose. It's just stupid.
And they're all looking out the window the whole entire time. Nobody saw it. Nobody saw a body. There's no injuries to match up with being hit by a car. The whole thing is
No,
just
it's like there's no thought that the prosecutors put into it. They just throw it all at the wall, hope some of it sticks. And, I mean, all of this is stupid in light of the ARCA stuff and in light of some of the other evidence, which I imagine will probably the defense would use at a second trial that they didn't use at the first trial, which I think would help them even more when they have if there is a second trial where they can really reset their arguments. So I mean, again, she's in really good shape today. Today is whatever comes of this. I mean, this is just a horrible look for those who believe that she just snuck by the skin of her teeth. It seems to be the exact opposite, that the DA just survived.
and after what happened today, the other jurors are going to hear about this, and who knows who else is going to come forward and say, who's not on Twitter, right? Who may not have heard about all of this nonsense being spewed
Well,
out
put it
there by
this way.
people with no knowledge, and they're going
Put,
to come out and say, wait a second,
put it
juror A is absolutely right. Like
right.
I'm
Or
calling Yannetti now too.
right. Or so let's assume hypothetically there are 9 jurors who have not in some way contacted anyone involved in this case. Wouldn't you expect that if this was not true and accurate, that a juror would call the DA and say,
Mhm.
that is not true? Now, maybe they will. I don't know.
Right.
But if that doesn't happen, I think, without reading into too much stuff that you shouldn't read into, I would find that very telling, because if I'm one of the 9 other jurors and they're spreading a non theory that isn't true, I would either contact the court or the DA and say, look, not for nothing, I don't want to be involved in this, but that's not accurate. Or to
Right.
your point, what happens when 4 more jurors over the next 3 days call Jackson, call Yannetti and say, that's all true. That's all true. You just can't turn your eyes away from this. I mean, you're potentially
No.
talking about trying an acquitted person for murder. You can't have that.
Yeah, it's a constitutional violation. And what was that whole part in the motion about how double jeopardy is not codified in Massachusetts law, but we follow the US Constitution? Like, what?
Yeah, I mean,
What's going
that's
on up
pretty.
there, folks?
It's surprising that, most really progressive states, their state constitution would quantify all of these rights and then some.
Right. Extra rights. You have more rights even.
New York used to have actually a double jeopardy law that was actually even stronger than the federal one. So I don't know if you remember Paul Manafort, who was
Mhm.
tried a couple of years ago, and they had tried him in federal court, and then they tried him in Manhattan state court. And that indictment was dismissed on statutory New York double jeopardy grounds, even though it didn't violate the federal constitution. But New York really, which you would think Massachusetts would, because Massachusetts is as liberal a state. I mean, with
Mhm.
individual rights and as any place else, you would think that
Right.
this would be a stronger issue than the federal constitution. But either way, the federal constitutional concept of if you're acquitted, you can't be retried is, I mean, I think people in the 3rd grade know that.
Yeah, well,
I know.
some people that are adults don't seem to understand a whole lot of
Right.
anything, and they feel free to spew it publicly
Right.
for everyone to see, for the world to
Right.
see, I guess. There are 18,442 of you watching right now, but I'm only seeing 4,600 likes. So how about we all take a pause, hit the like button. Everybody say hi to Kelly Reed. Hi, Kelly. We love you. Thank you for coming in. And for the 10th, it's a great show, Melanie and Mark. Thank you for your consistent expert coverage of Karen's case. Kelly, I am outraged. I am outraged. This
Can
is
you imagine?
insanity, but I had an inkling that
Can you? I was just going to
this was
say, to
going to
be
happen.
to be Karen and her family, like Kelly and the others, and you already are just fuming at all of this stuff, and then you find out that three jurors on their own, unrelated, are just calling lawyers and saying she was acquitted of murder.
Hmm.
I
Yeah.
mean, in some ways, they. I mean, look, anytime a defendant walks out of court, even with a partial hung jury, that's a win.
Hmm.
But it's been a week, and they have already deprived Karen Reed at least a week of that comfort, knowing, oh my God, I may not be facing a life sentence anymore. I feel vindicated in the sense that they recognize, that I'm not some evil person who mowed him down. I mean, if nothing else, she should have been entitled to enjoy and feel better about herself knowing
Right.
that.
Like 1 minute of maybe being able to breathe and have a little bit of peace, maybe instead of, having some sort of vindication, some sort of like, okay, next we're going to have to go again, but we're only going to have to go again on count two.
And then you
It's
have the
going to be more
politics,
streamlined. It's going to be,
but you're also going to have the politics of the pressure on the DA is going to be even greater not to retry than it already was.
mhm,
You also think the feds are going to feel more vindicated in light of this. And I think they're going to do anything and everything in their power to help them win the second trial.
mhm,
Uh, so, I mean, if you're Morrissey, this is a public relations disaster, and there's no way. I'm waiting for the Coffindaffer et al. Spin on this and all
mhm.
of this nonsense.
Lies. They're all
There's
lying.
there's no good way to spin this. If I mean, and her spin and the others, well, they'll claim the lawyers are submitting false
Yeah.
affidavits because they have this irrational.
Mhm,
It's extended. They hate Karen Reed, and by extension, they hate her lawyers. They're all corrupt and lying because they actually believe that she's being framed and innocent. And of course, the more you learn, the more you see, and the more that happens. A lot of people believe that, including, at least with respect to some of these charges, two of them anyway, the jury.
mhm. 3 of them. Oh, 2 of
Yeah,
the charges. Yeah, 3 of the
yeah,
jurors, 2 of the
yeah.
charges. Pilgrim Shadow says, "Congratulations, Counselor Bederow, on your huge victory last week. Peace be with your client." And then quotes the Grateful Dead, "Let there be songs to fill the air." Anybody know what song that is? Mark?
I No, I'm not.
That's Ripple.
I guess I do that. I'm not a deadhead, but I
But I
listen.
know who Jerry Garcia is.
Well,
Uh,
no, I went to college with a bunch of people who would, with if I went to college in Arizona, and
oh, you did?
If the Grateful Dead were anywhere, basically from Seattle to Denver to the Mexican
Uh-huh.
border, then half the people would be gone for the weekend. You
Where
know,
did you go to ASU or U of A?
I did, yeah.
ASU, yeah, I was in Boulder. I was at the University of
Okay,
Colorado in Boulder. So yes, we drove to Tempe one summer to
there
see
you
the
go.
Grateful Dead. There it was that summer
Exactly.
tour.
These
They
people,
Telluride,
they
Tempe, Park
Vegas,
City.
Vegas all
Fantastic.
the time, or Boulder, of
Mhm.
course, like hippie
Yeah.
heaven back then. I don't know if it still is.
Oh, those were the days. Those were the days where nobody had a cell phone, but you would always find your friends. Meet me at the flagpole, 7:30 outside the Nassau Coliseum. And you would always find your friends.
Yeah.
Go Georgia. Thank you for tuning in from Australia. Melanie, you've been a shining light. The numbers watching now speak loud and clear and outraged. Thank you. We're up to 18,560. Did you guys get the likes up just a little bit? In the new YouTube format, you might have to close out the chat to hit the like, but it helps the algorithm, helps other people come and watch us. Judy Ron, thanks so much for the 20 holy shiitake mushrooms, Batman. Melanie, will you join me and Ed later tonight to discuss Proctor and all this? Yes, of course I will. Of course I will. Just text me, give me a time, shoot me a link. I'll come over to Duty Ron's channel tonight to talk about this because we are still outraged. I could talk about this all night.
Yeah, this is great.
Michelle says online people disregard ARCA because Lally said they only got limited information, implying their testimony was null and untrustworthy. Well,
It's are
Twit's
they?
gonna twit. Twit's gonna tweet.
Yeah, I mean, I guess people weren't listening to what they were saying, which is the
Um,
laws of physics and engineering are more important to me than a taillight piece, because a taillight piece could be put there by human hands. But
mhm.
I know that if you need X many degrees of force to, again, I don't understand the science of it. I, to me, I don't understand how the car accident is even a thing at
In
this point.
play, but at least you're going to get a new jury now if they're going to retry second count, and maybe the new jury will understand a little bit better. Maybe the instructions will be a little bit more clear, and maybe the verdict slip will be a little more clear. Thank you, Michelle, for
And
that.
they're going to be allowed to prep them. You know, they never spoke to them until they just threw them cold on the stand. Now they'll be allowed.
Right. They couldn't prep them. Absolutely. And especially based on that, like those guys were phenomenal.
And they know the cross that's coming and they'll prepare for it. And this is why a retrial there won't be a retrial, but if there was,
well,
it
will, whatever. We'd be sitting here either. So
I don't think there will be, but I also thought she'd get acquitted outright. So what do I know?
Unless Marcy resigns and somebody else is, you know, is the new DA comes in and is like, you know, we're not doing this. But I can't see Marcy dropping any of this stuff because his life hangs in the balance, I think, on this case in a lot of ways. His reputation, his who knows what else is going on behind the scenes. Like I started covering Sandra Birchmore last night, and if you're not, this. It happened in Stoughton. The Stoughton police officers groomed this girl. Horrible story. That's also the civil case is pending in Norfolk County Superior Court.
I know.
And it precedes the John O'Keefe murder by a year. So there's a lot rotten in Canton, Stoughton, Norfolk County.
Well, it's going to be really interesting to see, again, the pressure on Morrissey, what their response to this motion is, because short of getting jurors to say those other three are lying or they're, you know, as Roger Clemens used to say, misremembering, short of that kind of stuff, how do you, as a minister of justice wearing a white hat as a prosecutor, say that I'm not troubled and that this should not play itself out because we as honest prosecutors would never want to prosecute an acquitted defendant? But instead, the reality is they're probably going to fight it like hell and say that this is after the fact, should be ignored. I mean, we'll have to wait and see. Maybe we're being unfair to them, but I don't think so.
Nobody was ever searching for the truth here. Nobody was ever searching for the truth about what happened to John O'Keefe. Boston police officer John O'Keefe, right? Yep. The guy's going to catch a lot of heat, I guess. Boston cop who owns the house. Nope. He's a Boston cop too. Nope. We're going to pin it on the girl. Look the other way. Heather, Paul's the victim too. We need to have some understanding. That being said, we could all be Karen Reed. So we need to make sure the truth comes out. Agreed, Heather. Nobody's been searching for the truth out there, in my opinion, on the investigative side or on the DA side. I mean, the fact that Marcy came out and did that, what I call hostage video in August of 2023.
I called it too. That's funny. Yeah.
I said it looked like somebody was off camera holding a gun in his head. He was reading from a script. Like, I'm proof of life. It was like a proof of life. It was never in the house. Stop.
I'll tell you what was, I mean, look, obviously that press conference was unethical for, I think I said 13 different reasons, if I remember previously. But the scary part is, if you wanted to make a statement about, you know, don't harass witnesses, okay. I mean, no one should harass witnesses. I think we can all like find common ground, but every one of the people that he defended had attorneys. If they want to give a speech about how, you know, Colin's an altar boy and he's a good, harmless boy and they're all soccer moms and good people and they're innocent and Karen Reed is an awful murderess, let the lawyers who are not parties to the action and bound by the, you know, ethical constraints of Rule 3.6 do that. Awful.
And basically, you know, tainting the jury pool from jump. And this was when the federal grand jury had already subpoenaed all these people. They already testified in front of a federal grand jury. Like, he knew they were looking at not only this case, but potentially at his office. And he still goes out and did that. It's just mind numbing. It's mind numbing to me. Prestige Worldwide, thank you for coming in with the 20. I look away from YouTube one morning. Yes, I'm a Sun Devil too.
Someone is reporting in the comments that Proctor got suspended, no pay, which is the most extreme punishment he could get right now, which I'll go back. He's on his way to being terminated. He's just getting his due process. If that's accurate, I'm just reading from somebody said that in the comment, but if that's accurate.
Linda Clark. Thanks, Linda.
So that's a sign. He's on his way to being terminated. So when he testifies, I guess, as a defense witness at this so-called retrial, you know, he can testify as former trooper proctor and maybe explain why he is former, because I got fired for my conduct in this case. But other than that, disregard calling the tow truck before we ever saw the car. We knew she did it. Trust me.
Right. 16 hours, had it solved, figured out. They solved Sandra Birchmore's case in 4 hours. They ruled it a self taking of her own life within 4 hours, closed it. Prestige Worldwide, first of all, she says she's a Sun Devil too. And she is so amazing. She one day said, I will match all super chats and make a donation to MS Research in Karen's name. And we raised over $1,800. And she's amazingly, she's a benefactor. Like, you're amazing. Thank you, Prestige Worldwide. You are awesome. Mary, thanks for the 10. How could the jury dismiss the dog bites and no other bodily injuries? My Nancy Drew mind thinks he was in the house drunk, dog attacks, and he fell, hit his head. The cover-up began. That's a reasonable theory, because I don't believe she got hit by a car. I've been screaming that on court TV since January.
No, the dog bites, the no fractures, and the cut on the back of his head, which came from what? I mean, we could do this till the cows come home.
Right.
We hit the curb and then leapt 30 feet. It's just.
Yep. MG, just in. Norfolk DA's office looking forward to picking a new trial date after Karen Reed's attorneys file motion to dismiss charges.
What I mean. Only a zombie with no self-awareness would say this. Okay, let me help you out, Michael Morrissey, because I know you're not very good at PR and all that kind of thing. The only appropriate response would be, we received the papers today. We are in the process of reviewing them, and we will file our response in court. If you don't want to say anything, say that. Don't take a dig and say, I'm looking forward to picking a new trial date, dummy, when the defense is saying, yeah, but 67% of the case has already been acquitted. Mm-hmm. They have no self-awareness. But this is classic why they're zombies. That is the most zombie-like, stupid statement to make.
I can't even, right? We have no comment right now. We have to review the papers. We have no comment. We need some investigation. How about?
I'm sorry. I'm talking over you.
No, go ahead.
What you hope will happen is that some of the reporters now will call Alan Jackson or David Yannetti and say, have you heard the DA's response? Which is tantamount to standing on the pitcher's mound and saying, are you ready? Because I'm about to throw you an 85-mile-an-hour straight fastball down the middle. Let me know when you're ready. Because then they can just go off on how pathetic a response that is when there are serious allegations of just serious constitutional issues that could allow a woman found not guilty to be potentially put in jeopardy again for murder, and your only response is, I can't wait.
Looking forward. Thanks, MG, for the breaking news. Like your office isn't already under a microscope enough.
Yeah, I like that either. I mean, that's just poking them in the eye too.
I love all your baseball references tonight. You had a Roger Clemens reference in there, and then you just had like another pitching reference. So, but you're a Red Sox fan, right? You're a Red Sox fan?
Yeah.
Oh, yeah. Well, yeah. But Roger Clemens, didn't he play for the Yankees? I grew up in a Yankee family.
He started on the Red Sox, but
he did. All right. See, I guess I don't go back that far.
And the Blue Jays and the Astros. He became one of those guys.
Scott McGinnis, thanks for the 10. Massachusetts is running control of the Democrat Party. All of Massachusetts DAs are Dems. All the judges are Democratic governor appointments. Absolute power, absolute corruption. Sorry, but I found that I try to stay away from politics on this channel just because it's like so divisive. But I found with this case, I feel that the people who believed Karen Reed was innocent and the people who believe she's guilty, I believe they are on both sides of the political aisle. Like, I don't think this is politically divisive. I think it's just common sense versus.
Well, I think it's an interesting, because I've, just in following this now for a couple of months, this is like the one weird issue which appears to have no pattern with political values or beliefs. You know how like everything is like right, left, or I love Trump, I hate Trump, or whatever. This apparently is all over the place, because I've seen. Because some people, their profiles give away what they believe in the larger scheme of things. Right. And this thing totally transcends it.
Agreed.
I've never,
Agreed. And
I've
it's
never seen
weird
it
because,
go.
like Rittenhouse, you had all the pro-gun people on one side, maybe it was divisive politically. Same thing with maybe Crumbly, which was the case where the mother and father
Right,
were on trial for murder for their son, who was a school pew pew, as we have to say on YouTube. Um,
right.
Interesting. This is interesting, Athena. A lot of people have pointed this out. Thanks, Athena. Still bothered by the fact that no one saw the numbers placed in the box to select the final jurors for alternates. Like they're thinking it was like numbers, whatever, whoever it was, 3 and 4. Like those were the only numbers in there. I don't know. I don't know
I don't
how that
know.
works in Massachusetts. If they everyone has to, gets to look in there like I
This
don't know,
is the
like bingo.
problem with the whole case. There are so many things that are bothersome
Yeah.
that anything and everything people see with this case, they naturally assume that it's corrupt or fixed. And
Mhm.
a lot of these issues are not, but the point is that's like the public perception by a lot of people. And now, after all of this, on the same day, you have a state trooper who did what he did getting punished. You have 3 jurors allegedly coming forward and saying, we acquitted her. And like, they're not saying we acquitted her. I mean, the public confidence in this whole trial is so bad, and it's only going to get worse. And this is just an embarrassment as a
Yeah.
trial for people to watch.
I agree. I don't want to keep you too long because I know that you have a brief to write. Chloe Albert's Revenge says Trooper Paul didn't have all the info either, including the education, training, knowledge, or common sense, but they believed him. Hashtag
Yeah.
flat earthers. Yeah. Yeah.
Yeah.
Thank you, Mary Ellen, for your super sticker. Another Vice. Thanks for being a member for 4 months. Get rid of Auntie Bevan. Have a bench trial. That's the same thing that Mark says. Kathy Todd, thank you for your super sticker. When I saw that this motion dropped, I was assuming it was going to be like a motion for like a JNOV or something. Like there was not enough evidence to convict her. You have to overturn the verdict. Like, no, there's no way this should have been a mistrial. It was so obvious or something, right? I did not expect this.
I
This
don't
to me was a
think,
surprise.
no, I mean, I've seen like juror misconduct issues periodically brought up. One thing that I've never seen and assume we'll never see again is that a judge declared a mistrial on all counts and the jury is saying, what are you doing? We acquitted. This is humiliating for the court.
Yeah. Mm-hmm. Thanks. Another Grateful Dead reference from Little Irish Girl. If your cup is full, may it be again. I love it. I love the way you guys think in song lyrics like I do. Juliana, Bev laughed before Karen Reed, then reprimanded Karen Reed for laughing in front of the whole entire world.
In front of the whole world. Yep.
Phoebe Bird, could you please repeat what happened this morning? If my words did glow with the gold of sunshine. Oh, another Grateful Dead reference. And Laura says, Mel, what's going on? I can't get service at work. Saw the title and ran outside. They think I'm crazy up here. OMG. You want to take it? I've been reading all day. A little recap of what happened this morning and the documents that we read and where we stand and where we're going.
Well, the defense filed a motion alleging, as crazy as it sounds, that in the span of 2 days after the verdict, that 3 jurors separately and individually without any coordination contacted the defense and said that we acquitted on counts 1 and 3. So that would be murder and the leaving the scene. It's all hearsay. There's no affidavits from jurors because apparently they're not allowed to do that yet.
Yep.
And so they are asking that under double jeopardy principles, that because the jury acquitted her apparently on counts 1 and 3, that the judge enter acquittals on those counts, which she's not going to do, or more likely allow us to take further evidence in advance of an evidentiary hearing to create a record, at which point we'll ask you to do that, which very much could happen, assuming that's what they meant to do. The deck is normally stacked against them. You don't like to undo what juries have already done, but it's not common that you have jurors be the ones who start the contact. I mean, a lot of times, anytime there's an allegation of a juror, oh, I was confused, the defense contacts them, they get an affidavit, and the other side argues they're intimidating them and whatnot. Here, it's being alleged that three, not one, on their own, separate and apart, all came forward because of news stories reporting that, it was apparently a strong, almost conviction on these counts. And then we had a chuckle at some of the online yahoos who put that out there and ironically probably led to the jurors seeing this in the first instance, which led them to do what they did. And so now you're in a situation where at least two of these hung counts are at least potentially in jeopardy of being acquitted counts if there's credible and admissible evidence to support that.
Yeah. And like Marcia says, thanks, Marcia, for the 20. I was so upset when another host on a reliable show declared his reliable source declared that the verdict was 10-2 to convict. And that's exactly what we're talking about.
Well, I made a joke about this the other day when this happened, when the self-styled towel put this out there. I said, I look at this as a integrity test for basically the useful idiots. Like, let's just sit back and see who exploits this and takes it. And we don't have to mention names, but all the usual suspects you would assume all started running around using this as the, credible basis to spread that there was this 10-2 in favor of conviction. And it got out there so far. I mean, it made its way to a former editor of the Boston Globe, which is just, my God, check your source, man. Your source is a towel calls himself a towel.
Here's Haley coming in with the 20. If it wasn't for the towel, some of those jurors may have never been inspired to come forward after seeing the fake information. Thanks, Grant.
That's exactly.
Wait, have you been accused of being Haley yet? Because
no.
I'm still Haley. Maybe. I don't know. It changes daily, I've heard.
No, I haven't. I've been accused of a lot of things. I have not been accused of posing as anyone else. But this points exactly what we were laughing about. The irony is that this clown show online essentially may have very well led to this becoming an issue. The jurors may not have known that this was even a big deal, that this was normal. They're not legal experts until they start seeing, they're saying it was 10-2.
Right. Amy. Thanks, Amy. They have to be heard on this motion, correct? Yes. Another judge?
Well, yeah, I think they have to be authorized to gather evidence, and then they submit more evidence. They ask for a hearing. They get the hearing, and I think you're going to see them ask that it be held in front of another judge, and if they're going to say that Your Honor is a witness, and that's a way to potentially not only win this hearing, but if they're thinking the long game, I don't think it's any secret. They would prefer to be in front of another judge, and this may be the way of killing two birds with one stone. Again,
though, Amy points out Bev could just deny it if she's the decider. She could just deny it. Like, okay, no, sorry, motion denied. I did all the pre-trial motions. Like, you can't imagine. Like, the only thing she ruled from the bench on, the only motion was the motion to recuse, where she said, I am not going to recuse myself. That would just mean that any judge in the world, people could say things on the internet and it wouldn't matter. And every judge would have to recuse themselves. No, I'm not doing it. And that was it. There was no written decision. It was weird. So I suppose she could.
The problem is this, though.
Technically.
There's only 13 people, presumably in the world, who know what was said between the judge and the jurors after this happened. And if there's no further evidence taken, there's no hearing, there's no affidavits, and she just denies it summarily, what if there was some discussion about this? And
it's a problem.
It's a problem. And I'm not saying they did talk about it. They probably didn't, to be honest with you, but I don't know.
Right.
But she shouldn't be she's still a logical witness in all this because she had private discussions with the jury right after this happened. And the reality is, if you're the DA and you get sucked into this and there's a hearing and you want to establish it, why didn't the jury mention it during right away? If you're in front of another judge, don't you want to call Judge Cannone and say, look, Judge, we have the best witness imaginable. The judge says it didn't happen. If you can't credit the judge, who can you credit? Never mind the jokes that some people will say. I'm saying in a courtroom.
Right.
So from the DA's perspective, wouldn't you want the judge to be a witness if the position is nothing was said in there?
I would. Absolutely. I also wanted Morrissey to take the stand. I thought he should have been forced to get on there and talk about how he knew what he knew, and what his statement, but we never got that far.
Yep.
Nico, thank you. Telling everybody to hit the like button. He says 15K online, but we're over 18K right now. So everybody click the like. It helps the YouTube-ish algorithm things. Quilta G, thanks for the 10. Bias Bev will try to wiggle herself out of this and not take accountability for these mistakes. She's starting to look like Judge Glanville in the YSL trial. I haven't followed that trial at all.
I mean, that one's pretty bad. I don't watch the trial other than I'm aware of when there was an allegation of an ex parte conversation. His response was, "Who told you that? And if you don't tell me, I'm going to throw you in jail," which is not a great way to handle that. But
Oh,
I'm not sure I would put Canone on that level.
Not yet.
I mean,
not
is
at all. I thought she was very friendly when we were in court that day. Said her vibe was very nice. She had good
Yeah,
vibes. She was
yeah.
very friendly in court, and I thought she was genuine. Ruby,
Yeah.
thanks for the 10. Murder 2 is where all the intent evidence came in. Aruba, John and Karen Tex. Leaving the scene is where consciousness of guilt evidence came in. If neither is retried, that evidence doesn't come in, right?
Not necessarily. Because, I mean,
Not necessarily.
the argument is, again, I'm not crediting this argument, but playing devil's advocate, I mean, the argument still would be that, she left him there, presumably aware that she hit him or should have known, and then, moved her car to Dighton. And look, to me, this argument is all stupid because they moved the car to Dighton. There was a garage there. I don't know, maybe put it in the garage, turn it around.
And several on the way back that were actually MSP, Sallyport barracks or whatever they call them.
Right.
That didn't go into the conflicted police department, Sallyport.
I mean, I think the comment raises a fair argument that the defense could make, but I don't know that it would necessarily keep out some of this nonsense. It could.
Yeah. Arlene said, I'm kind of impressed and thankful they offered therapy. Serving on a jury and the outcomes could cause a little havoc on one's mental health. Did you see that in the affidavit that the jurors said they were offered free counseling sheets or something?
I did. I'm not sure what the point of including that was. I don't know what, other than I guess it was hot in there, but
I don't know. I mean, they were offered like therapy. I was wondering what counseling meant. I'm guessing it was therapy.
I don't know.
Mass Bay Cannabis, thanks for the 10. Thanks. Will anyone answer or be accountable for intimidating the jury in this case?
No.
Cheers. No, I don't think so either.
Nope.
I don't think so either. What options does Bev have with this motion? She can call a hearing. She's going to wait for opposition for the Commonwealth. She could set a hearing. She could allow Jackson to get affidavits from these jurors directly.
I think the logical order of this would be, I swear to God, I had it on silent.
Oh, maybe you only had it on Do Not Disturb for like 1 hour or something.
Yeah.
I taught him how to do it, everyone. It isn't me.
She did. And no, it is me. I mean, I think logically the first thing she'll do is see what the DA says. And then I think the first issue to consider is, do I allow the taking of other evidence from jurors? And then let's report back. And then if that comes back, do I order a hearing? And then if I order a hearing, who are the witnesses? And what do I do when they say they want me to be a witness and kick me off?
Yeah.
Sounds like fun.
Thanks, Amber. Just Linda, I think we already answered this from Canada, but can Bev dismiss this? I think this was a duplicate question. Yep. Proctor's really suspended without pay. Thanks, Allison, for the 10. Proctor suspended without pay per 25 News in Boston. Well, they're going through the motions. As Sean McDonough would say, they're going through the motions. They are doing what they have to do under, I don't know if they have a collective bargaining agreement, the union, or how the union is
it's so
what
hard
their procedures are, but it seems that there's a lot of hoops, right?
Yeah, but he's getting fired because also it's not all just because these are like moral people who are appalled by him, which I think some are, but there's like a more practical, earthy reason. He's useless to the state police. He's literally he's
a liability.
He's just a pulse and nothing else. They can't investigate cases with him. He can't testify. He's basically corrupt. He's garbage. He's everything bad you could think about a human being. And why would we want to keep him around? Like, what does he add to the organization? He's useless to us. So he'll be swept out with the garbage as soon as he gets his due process. He's toast.
Italian rum cake. Judge said if not guilty on second degree charge, then stop deliberating. I don't remember her saying that. Second-degree murder, then stop deliberating. Oh, if not guilty, then stop deliberating. Did she
No,
say that in her instructions? No,
no,
because they still could have found her guilty of
yeah,
2 or 3. So,
yeah.
I don't think that's right. Barbara Brady, thanks for the 10. I was on a jury in Queens, New York, multiple charges. We were hung on 2, and the judge made us stop, pulled us, read verdicts in the court. We had a man who refused to deliberate and covered his ears. Bev knows. Yeah, it's New York, Barb. Barb, New
And
York
this
is
why,
so different. It's like a different
and,
world.
and this is why that 2-month trial I just finished in Queens was a bench trial.
Because if it was a jury trial, it would have been 17 weeks in Queens.
With, a juror who refuses to hear anything.
Lori Joyce says the fish rots from the head down. Proctor's only the tail. Thanks, Lori, for the 5. Pure Heart, thank you for this super sticker. Michelle, again, coming in with another 5. Exactly, Mark. We saw too many sketchy things, heard too many lies, phony experts who can't trust anything from the Commonwealth. We have lost faith in them.
Yeah, it's bad out there.
LGK, Judge Canoni showed bias, trial to the end, confusing verdict sheets, jury to act on verbal instructions, not written, not reading each verdict as voted. Well, we still don't know that they gave her a verdict slip, so we'll have to reserve decision on that one. Confirm Proctor suspended without pay. WBZ News. Thank you, Suzanne. I'm getting a bunch of texts on it too. Seems to be out there. Not to mention, Pure Heart says Bev spoon-fed Lally the whole trial. I was like,
She
Mommy, Mr. Lally, would you like to object? Can you answer that question? Like it was so weird. What do they say, Mark? Facts are stubborn things. John Adams. Thanks, LT33.
Line all the time. Yeah. We all quote John Adams.
Right. I guess John Adams is the guy.
He said that when he was defending the British troops in the Boston Massacre. He took the unpopular position.
Were verdict slips filled out? Adam drives Helen. Paper trail be nice. We don't know.
We'll have to see. Yeah, we don't know.
We don't know. We just don't know. Thank you, David, for the 10. There was no option on the verdict sheet for not guilty on each individual charge. They only had an option to check the not guilty for all charges.
We didn't see the second verdict sheet, though. Remember when she agreed
corrected
to fix it, but we don't know what it said.
I have it somewhere, but I can't find it right now. I think maybe, yeah.
Look, if the verdict
and that was the charge they were stuck on, by the way. That was charge number 2.
I mean, if the verdict sheet has like not guilty boxes for each count, and on like the murder count, it's not checked off, then the DA would argue, well, that that's stronger proof than jurors after the fact coming forward. They had a chance to do it, and they didn't. I mean, that's what they would want to say, but we don't know what the sheet shows.
Debbie says, where's the OUI? There was no standalone OUI. It was leaving the scene under the influence. Right. There was no standalone drunk driving charge.
Right.
She was not charged with that, and the defense did not want that in there as a lesser included. Oh, Lulu has our nickname, Eminem. How and why do you think this happened? Because the jurors were outraged that they were being misquoted on social media about their split, and that's why they came forward, and that's why I think it happened. What say you, Mark?
I think they saw these stupid reports from trolls or whatever you want to call these people, and it's very interesting when you have actual knowledge of something that somebody is saying is not true because you are literally there, as opposed to it makes sense to me. Like, like in this case, we don't have actual knowledge. It makes sense, but we don't literally didn't see what happened. And imagine being a juror, knowing that you acquitted on the murder count, and then you have to read, towels and other idiots online saying, oh, it was 10-2 to convict. I mean, and it's not true. I think that might encourage you to say, I want to be heard and say something. That's just offensive and not true.
And it's usually angry people that are louder than happy people. Like, just look at like something like Yelp. It's always the people who are complaining, or TripAdvisor. The reviews are always from angry people. People who have a great time or a great experience don't tend to write reviews. It's when people are angry that they do something. So that is my guess, that they were like, don't you dare misquote what happened in our jury room. And not to mention, here's what really happened. We acquitted her on 2 of the charges.
Yeah,
Melissa, if the juror told the judge this information, jurors, and she ignored it, what happens with that now? Any consequences for her?
that's bad. I was talking about this on that little break I had.
Mhm.
I mean, there's nothing she can do like with the verdict at that, or the lack of verdict at that point. But obviously, if there were jurors who were telling the judge, oh my God, this was a mistake, and what she should have done is call in the parties and say, I have to tell you something,
Mhm.
and report factually what happened, and say, does either side want to be heard about anything at all to do with this? Not even like state anything that she wants to do, but let the parties say what they think, and then nature will take its course. And the defense would have said right there, we this is a problem. We need to look into this. But if the judge held that back, that's probably judicial misconduct.
Huh. Yep. And
There's
then what
no way
happens to her? What
on that.
happens if there's judicial misconduct? What's the next step there?
Well, I think then you have a hearing. She's a witness. She's thrown off the case. And then the next question is the difficult questions. I mean, she could be cross-examined by a Karen Reed lawyer saying, if the jury was making it clear that they meant to acquit, and that you never explained that to them, how do you not tell that to the parties? Now, how do you
Yeah.
possibly answer the question? There is no answer.
Mm.
But I'm not suggesting that's what she did either.
No, El Jefe was right, says Paul O'Keefe. Paul O'Keefe's something.
Pro-
Thanks. El Jefe meaning Sean McDonough. I think he means Sean McDonough.
It does, but
Yeah, I didn't read it. Breezy, thank you for the 5. This seems so wrong. How could this judge not reveal this? I'm floored. This alone
wait
should
a
be reason enough for the judge's recusal. We don't
We
have
don't
any evidence
know.
that the judge knew anything at all.
I think in all fairness,
So let's not go there.
you have to allow yourself for the possibility, in fact, probably the likelihood, that she went to talk to the jurors as a representative. Look, she's the judge. They
Just to
just
say
sat
thank
there
you.
for 2 months. As
Yeah.
far as she believes, they couldn't reach a verdict. They just wasted 2 months of their life. They've been telling us we're emotional, we're this, and that she's saying, I really appreciate the effort you put in. I know this was difficult. We all think it may very well be nothing more than that.
Right.
Literally,
Like, you
just
guys feel
thank
free to take the donuts home with you.
Yeah.
It could have been anything.
Yes, you can't assume. She's like, what do you mean? What do you mean? Like, did you
Right.
understand? You
No.
don't know.
No, the error was in not asking them on the
Yes.
record if they had acquitted on all charges or one or more.
It was indefensible for her to do that. Or, as we said last week, when the first note came back and she said, I'm going to send you back in, to say, you don't want to tip them off because you don't want to encourage a hung jury, obviously.
Right.
But she could have said, just make sure that you consider each count individually, and that
Right.
you need to reach a verdict, each one individually. And I guarantee you that if she had instructed them on that, and then they were kind of half hung on a few, but wanted to acquit on another, that they probably would have sent a note saying, what do we do if this?
Mm-hmm.
She could have very easily said, if you have certain counts that you can reach beyond a reasonable doubt, you should do so.
Right.
And then that's what I'm asking you to do.
Right.
And not encourage a hung jury. But I mean, it's kind of common sense. So
Yeah. I mean, if you have a hard stop, you just let me know when you have to go.
I don't. I'm good for a while. I don't
All
want to
right.
write anymore. I mean, I have plenty of time with this. I do like
Your
4 or 5
writer's
hours
block.
a day.
Ugh.
No, it's just kind of boring.
Is it a brief or is it a motion?
No, it's an appellate brief in the second department.
Wait, you do that too? You don't got a guy for that? You got to get a guy for that. I got a guy. I got a lot of guys for that if you want, who don't do only that. And like, you should not be doing that. You should
I
not.
know.
You should get a guy. Got to get a
Yes,
guy.
I sound like Saul Goodman. I know a guy who knows a guy.
I got a guy.
I
My
guess
dad
that
had a
means,
guy for everything. I got a guy. I got a guy.
know
You
a
need a
guy-
guy? I got a guy. I got a
Oh,
guy
you
for that.
actually, that's talking about Gus Fring, because he means I know Mike Ehrmantraut, who knows. Yeah,
I got girls
no,
that do too. I got girls too. Appellate. That's all they do is write briefs. They love that because they can do it in the middle of the night when their kids are asleep. Marcello, thank you. Bev did not like Karen. It was obvious she didn't, and she wanted an acquittal. And worse, she didn't want an acquittal. In worst case, she wanted a hung jury. I don't doubt for 1 second she did it on purpose, especially the verdict instructions and shenanigans she pulled. That is Marcello's opinion and not necessarily my opinion.
but that's the problem with this whole case. Is there's a lot of people, whether even if we think that's too far, there's a lot of people who think like that because of what they've seen in this case.
What about this? Freedom ring. Error not preserved by defense is waived. I don't know what that means. Mean by the defendant?
No, I mean, what were they supposed to do?
Right.
They haven't waived anything. The juror called them. There's
After the
no
fact.
how could the defense be aware? They were contacted by the juror. It's not waived.
Thank you. Thank you. Melissa, Michelle is just thanking us for being with everyone. Thank you guys for tuning in. Miss Mojo Horizon for the Jim Morrison super sticker. Thank you very much. Who's responsible for keeping Bev in check once
Nobody.
RJ and there's no like judicial like overseers board in Massachusetts, like the grand
She's the,
poobah, the grand
well,
poobah of judges.
she's the queen of the county. I mean, she's the head judge out there. So I guess it would have
She
to be
is
the
the head
state.
judge.
Yeah, no, I think she's the like chief judge in Norfolk County. If
Oh,
I'm wrong, correct me. My
I don't
understanding
know.
is I think she is. I think she's like the chief administrative judge out there.
Freedom Ring, same viewer says defense counsel should wait in sooner on the verdict. Should have anticipated partial verdict. Should have asked the judge to pull the jurors. Issues waived. No, that's not how it goes.
They could have asked. I mean,
can you pull them though at a mistrial?
No, I
On
poll
a
is not
hung
the word.
jury, you can't pull them.
No. No, but I think what they, I guess, could have done was before the jury comes back, say, Judge, please make it clear that we need to know if there are certain counts.
There was zero clarity in anything in this
That's not the
trial,
defense.
especially from the Lally. But
that's
thanks, Freedom Ring.
It's if the judge doesn't do something that the judge is sua sponte obligated to do, they're not waiving anything. That's. By the way, can you imagine being the DA and making that argument? There's credible evidence that this woman was acquitted of murder. We intend to try her on murder, but even though there's credible evidence that she was acquitted, you shouldn't listen to that argument.
Back.
She waived it.
How could they even like oppose this? They really can't. I mean, without looking stupid, unless they just say we consent to a hearing because we want to know the truth. But a lot of people think they were not looking for the truth at all. Rob Henriksen, music. Thanks for your time. Thank you for your input all these weeks. Love the Dead and Comedy poster in the background. Oh, thank you. I think that's the Forum poster from this year. Thank you so much. That is my happy place. And I do love the LA Forum, one of my favorite venues. We have a lot of just comments. Let's see. Do zombies typically attack their own because someone definitely chewed on Lally's brain? Thank you, Chloe Albert's revenge. Brian Albert, repercussions for handling, for intimidating the jury. I mean, there are none. Somebody else said, member, buzzing for truth. Mel, I take it the juror felt intimidated by Albert. That's what the text messages seem to
interpret kind of scary. As. They thought it was Higgins, as if literally they're just fungible goods. They're like big meatheads that look the same and they can't distinguish between meathead A and meathead B. It's.
What did you say one night? You're like, meathead's going to meathead. Meatheads are going to meathead, and that's all there is. That's all there is to it.
They heard evidence for 2 months, and they couldn't, at the end of the day, distinguish between Albert and Higgins. That's remarkable.
Thanks, Jennifer Bossert. If there was an attorney on the jury, I would think the attorney would know the importance of filling out that verdict slip.
So would I, unless they were, a contracts lawyer and just may not know how this works any more than a non-lawyer.
Yeah, that's what Ashley says. Do you think the attorney deliberating felt like he had an ethical duty?
Maybe. It wouldn't surprise me if the jurors who did this were the lawyers because they felt like this is just not right. I don't know.
LTL 33. Thanks for this. Do you think other jurors may come forward on their own now? I do.
Yeah. I mean, this is a huge story. And what's interesting is which side do they come out on? I mean, in theory, there ought to be 9 other people who say that's what happened. And if there's at least one who doesn't, how do they not go after or help the DA?
Anton says state may pursue charges against Proctor according to Boston 25. I didn't see that.
I didn't see that.
I mean, I saw that he's suspended without pay. I don't know what charges the state would pursue. I was thinking federal, but I don't know. Perjury? I don't want to state that as fact, but thank you so much for the super chat. Lala, do you think Marcy and Bev is in it together and they didn't think the jury would get involved? No, we're not going there. We think the jurors came forward because they were outraged. Whatever floats, or that's what I think anyway. I can't speak for you, Mark. The alternates were picked after the foreperson. Yeah, I don't. Maybe that's how it's done in Massachusetts. We are both New York attorneys, so you guys do a lot of things
Yep.
differently there.
Yep.
If AB had asked, would you have taken this case, Mark?
Who is
AB.
AB?
Would you
I
have
don't know
taken
who
his
AB.
case? Oh, if AB had asked, I don't know who
Who's
AB is
AB?
either.
I maybe I don't know who AB is. I'm looking at that
I'm just
25
a girl in
article.
the world. Thank you for your 20. Karen Stevenson, thank you for coming in with a super sticker. Somebody's
Somebody-
asking a question. If they don't pull the jury, does that waive their rights later? Nope. Nope,
No.
because this was a hung jury. This was not a conviction or an acquittal. So if I like on a conviction, would they waive it if they don't pull the jury? I don't know. The answer to that is Massachusetts law. And that is all weird.
No, I mean, again, this is an issue that they could not have possibly known about. The jurors came forward. I mean, you're not supposed to assume. Hold on, I'm reading the.
All right, you do that. I'll thank some people in the meantime. Sammy spills the tea. Thank you both for being on. She says, couldn't wait for Young Jerks tonight. Glad I got my Mark fix early.
The article says it's about the internal affairs pursuing administrative charges that would be adjudicated by a state police trial board. That's not criminal charges. I'm making sure there's nothing else in here, but so that's a
okay.
little.
So like an administrative proceeding.
Uh,
Varushka, thank you for your super sticker. Adam Drives Heaven says, love Auntie Mel and Uncle Mark. Thanks, Adam Drives Helen, Auntie Mel and Uncle Mark.
God.
Mary Malarkey, thank you. A movie coming for sure. Hoping for Pfeiffer and Clooney.
Interesting.
Karen Connolly, thanks for gifting 5 memberships. You're so kind and generous. Oh, AB is Alec Baldwin. Thanks, William Swanson. Would you have taken Alec Baldwin's case?
Of course. I had it on in the background. I know one of his lawyers who's constantly in the court TV footage.
Oh.
But yeah.
he can pay.
Alec Baldwin, he's not a likable person.
Mm-hmm.
Let's be honest. He's very wealthy. He can pay the freight. It's a very triable case, right?
Yeah, I think so. I mean,
yeah,
that's the thing. A lot of people just don't like him for whatever reason, but he's a Long
Neither
Island
do I.
guy.
Neither do I. He's like totally unlikable, but nevertheless, yeah. I mean that's one that most lawyers would not be.
His that Stephanopoulos interview is going to be a problem for him, in my opinion. Did you watch
Well,
his
yeah, the whole
Stephanopoulos
idea
interview?
fire the gun that doesn't make
Somebody's
it
responsible, but it wasn't me. Well, like
Right.
the Shaggy defense, it wasn't me.
Right,
Christopher
right.
Michael, thank you for your coverage. Says you've kept my mom and me sane while she juggles her chemo, radiation, and spinal ablation recovery. Wishing all the healing vibes to your mom, Christopher. So thank you for watching, and I hope that she is feeling better very soon. I think we covered this. If she's not guilty of murder, not guilty of leaving the scene, what is she guilty of? They were thinking charge number 2. Hopefully the DA will see this as an easy out and take themselves off the hook, says Gringa.
Their response today to this motion was, we're ready to go.
Yep.
So
can't wait to pick a trial date. Looking forward to it. Looking forward.
Today is the equivalent of a legal shotgun blast to the chest. You knock them down, right? This is a big blow. And what does the DA do? They just get up and are walking towards you and say retrial. The Walking Dead.
The Walking Dead. Lizzie B. Bevstein biased during the trial. A lot of people felt that way. Chloe Albert's Revenge. Funny, but this was the place colonizers ran to escape trials without juries, and then they devolved into burning witches and charges based on crayon drawings. Yeah.
Hold on. So somebody sent me the verdict slip. Hold on.
Oh, I have it too somewhere. But yeah, take a look. All right. Well-hung jury says she'll say no. They heard this info after mistrial. I like that. Well-hung jury. She'll say no. She can't say no. She's got to have a hearing on it because this is a violation of her due process.
Well, this is interesting because if I'm looking at what I believe, hold on, pull it up again. And don't ask me how to share it because I have no freaking clue. Um, there's a jury slip for leaving the scene of an accident,
Mhm.
and there are two boxes. We say not guilty or guilty.
Yeah.
And if you look at the verdict slip for where is the murder one, hold on. Uh, Not guilty or guilty. There was a box to check not guilty. Now, if
Mhm.
those boxes are not checked, then the defense is going to have to explain the jurors who say we voted, that's a fair game for the DA to say, well, what are you talking about? Why you guys are educated people, check off the box. If it is checked off and the judge held it to herself, which I just find so I can't go down that road to believe that would be a scandal. But I wonder if what happened here is that they orally determined, not guilty on those counts, but then said once we're hanging on the other count, that all we have to do now is just say hung jury across the board. And that, in other words, they all believed that they had voted an acquittal, but nobody took the time to check it off, which also makes the foreperson, whether he's one of the three jurors or not who said this, he has to be a witness too, because the question is going to be, why didn't you check the damn box if you voted her not guilty? He's the one who is the unfortunate task of literally checking the box, who presumably didn't, unless he did. I don't know what he'll say.
I mean, here's a sheet, but I don't know if this is the amended one or if this is the original one because they did
No,
amend it
that's the
after this.
original. I have the amended one,
Okay.
where each one has not guilty and guilty.
Okay, so then this was the first one where it just said not guilty, and then it said
Yes,
guilty of the
I
lesser
remember
included.
this.
That was the
This
first
was
one.
the one they went berserk about, which
Yeah,
and
rightfully so.
right, right, totally. That was
Mhm.
ridiculous. But the other the second one, it there's choice A and choice B, not guilty or guilty as charged. It says.
Mhm. Agreed. Yes. Wildflower. Something about corruption and Auntie Bev. Thank you for the super sticker. Pilgrim Shadow. Presidents John Adams and Thomas Jefferson died on the same day, July 4th, 1826. Very interesting. Melly, thank you for your super sticker. Coffee Cake, thank you. The corruption is real. Holy cow. Reality Squad, thanks for the super sticker. Daria, thank you so much for gifting a membership. What the actual fluff says you ain't all right. Thank you for the 10. Guy with cancer. I don't think the judge is corrupt. I think she just sucks.
But that's better than I think believing. I listen. If they checked off the box and the judge just kept it in her back pocket,
That's a
which
problem.
I don't believe that happened. If that happened, then the scandal hasn't even started, because that would be
Yeah,
so
that's
outrageous and corrupt beyond belief. But that's just really, really hard to believe. And I think
yeah,
just because you don't like the judge and she does things you don't like, it doesn't mean she's literally saying, how do I, do an innocent woman dirty because I don't like the way she smiles? That's a
yeah.
hard
She
sell.
laughed, and so
Gonna
I'm
convict me.
gonna make her pay.
I'm gonna make her come back and be retried for a crime I know she was acquitted for. I don't know.
Spend
That's a
another what $1 million or so on a defense. Like
ugh. Well,
Heather is frustrated. Says hopefully the jury slip wasn't filled out again. I'm sure Bev questioned the jury and knew how they were hung. I don't know. I don't think so. I mean, like she's held to a real high standard. If she did, it's going to be a big problem for her. If she
yeah.
did and did not tell the attorneys, that's going to be a big problem. Shannon says, not Grant the towel. Ugh.
Grant's
Keep
the only
reading something about all 12 jurors felt intimidated by Brian Albert's presence. I don't know if all 12 of them felt that, Cindy. Did it say that? I thought
I don't
one of
think
them
it said
said that he
all
did.
12, but it also called him Higgins. So
Thanks, Cindy. Right. Did the jurors also contact the Commonwealth, says one day at a time? We don't know. Sarah
probably,
can't get past the fact. Go ahead.
I was just gonna say, logically, if you believe you acquitted her and she's getting screwed publicly, I think common sense is going to make you gravitate to the aggrieved party and say, I'm just letting you know this
This is
isn't
what
right.
really happened.
And not
Yeah.
for nothing, the one alternative juror who also spoke said, I don't think she was guilty either. Not that that
Right.
carries any weight on the motion. I'm just saying
Right. Because that
the
one didn't deliberate, but
but it appears that the defense did a lot better with the jury than, the online lunatics
Yes.
were,
So there's that.
right, giving them credit.
Sarah can't get past the fact that 8 people even believe that Officer John O'Keefe was hit by a vehicle.
Well, you also run the risk of, and this is always dangerous, like the potential to compromise just to get the hell out of here. And you
Mhm.
want, and that's why juries are dangerous sometimes, but you want to go home and say, fine, let's just, I'll give you this count if we can just end this. And you start losing what you're supposed to be doing. Because I think if you thought it through carefully and listen to all the evidence, there's at a minimum reasonable doubt about the car accident. And if there's reasonable doubt about
Tons,
a car accident that she's not
tons of it.
guilty, nothing else matters.
Yeah. Yeah. I had Ali Mata on with me one day. She's from Defense Diaries. Her husband, Bob Mata, his
Right.
dad represented John Wayne Gacy.
Oh, got the clown killer in Illinois.
Yeah, isn't that him? Yes.
Yeah.
So
Oh,
his dad was the attorney for John Wayne Gacy, and he did like a whole like series podcast about it. And Allie was like, I would have said in my closing, because she's a practicing criminal defense attorney too. If you're back there in the jury room thinking about alternate ways that this could have happened, right away, that's reasonable doubt. Just stop. It's reasonable doubt. And yeah, truth.
Hmm.
Edie Yee, thanks for the 10. Paul O'Keefe is what it looks like to be brainwashed with tunnel vision. Anyone who even remotely cosigns and not denounce Proctor's behavior as problematic, it tells a lot about their morals.
It was cringe, as well as his vigorous defense of, what good people the Alberts are. And I mean, it doesn't mean they're killers, of course, but but he's been brainwashed, and that happens. And he has the right to speak his mind. It doesn't mean that we have to think it makes any sense.
Right. Crypto tax lawyer just joining y'all. Second high profile mistrial for Bev within a year. Love Melanie and Mark. Chesna, I think resulted in there were 2 mistrials, I think, in that case, from what I hear from all you guys. A Finding Nemo moment, says Eladia Lopez. Thank you very much for that. Thank you, Elf, for gifting a membership. You're awesome. What options does Bev have? Oh, we went over that, Amber. Thank you very much. Unless you have any more options that you've thought of in the meantime.
Mm-mm.
Reality check. Could you pull the law on jury intimidation and tampering? I can't do that right now, but
You don't need to, because they didn't do anything. They just sat there. It's a public courtroom.
Right.
It may be distasteful, but the fact that some juror felt sensitive about it doesn't mean that it was anything wrong about doing it. And they may have intended to intimidate, but that doesn't mean no one's getting arrested for that. I'm sorry.
Which is weird because the witness intimidation law says if you hurt a witness's feelings, that is witness intimidation. But jury intimidation, I mean, I don't know what their exact law is, but it seems odd that witness intimidation can just lead to hurt feelings and you could be convicted of it.
You still have to have some degree of intent, though. And
yeah.
The reality is, if you're Brian Albert, your defense is, I didn't come here. I was asked to come here, and so I came. I didn't. It wasn't my choice. They asked me to come, so I came.
Mm-hmm.
Look, you can dislike them all you want. Going after Brian Albert for juror intimidation is a waste of time.
Yeah. Sue says, what a sad world out there. Karen Reed's not guilty. Nikki Johnson, Auntie's sitting alone somewhere with a cigarette in a highball glass. Thank you, Nikki, for the 10. Lynn, thank you for the super sticker. Steve, after absconding Karen for smirking, Bev was determined to make sure one of the charges would stick. I don't know. Thanks for your thoughts. Spoken TC, something in the air, Thunderclap Newman, adding to the playlist. Hi, Lauren. A whole mess. Thank you, Melanie and Mark. Thank you, Mark, for getting in touch with me while I was in a place with no signal. Remy, thank you for giving 5 memberships. You're so kind. Alina, Bev knows, fishy fish, wish no more that the trial was a little tiny bit fair. Have a great summer, you two. Thanks, Lena. We're still going to be here for the summer. We're not going anywhere. Another Vice, please say, there's a man passed out in the snow. There's a man passed out in the snow. And then I heard the cleaned up audio that somebody posted. Was it Microdots?
Yeah, I got to tell you, if there were a retrial, that part where she whispers to Nicole Albert, they're sending someone.
Mm-hmm.
I mean, I know we had heard that, but for whatever reason, I didn't pay much attention to that.
Yeah.
That implies knowledge of what's going on. And it's no different than, Hoslong to die in the cold. Why would Nicole Albert and Jennifer McCabe know anything other than, and you're calling your sister, You don't know it's being recorded. It's this gratuitous phone in the back seat
Mhm.
recording it. You're whispering and you're saying they're sending someone, which is like, get everyone ready.
Or like
But
someone's coming to help. I think someone's coming to help or whatever it is, indicating that
but
she knew what was going on outside, that Nicole knew, or Brian or whoever answered that
that,
phone,
yep. And
and
at
it's
a
being
retrial,
handled. It's being handled.
at a retrial, I would think that they would play that up much, much more.
I think so too. I mean, I think there's a lot of things that
Those
will be
videos,
different that will ensure a not guilty.
the video of the Sally port, how the left light or the left tail light appeared
Yes.
to be damaged based on, again, I'm not a science person, so I don't know how
Mhm.
you manipulate the video, but that's fascinating to
When the
me.
person walks in front of it, the
Yeah.
white light goes on his back. It's
Yeah.
like whoever edited that video is the same
Yep.
moron that edited the Alan Jackson grabbing Karen around the boobs video. Like the facial implantation on that deep fake video was so bad that it was laughable that everybody ran with that too.
I see
So,
I see a Pulp Fiction reference in there. One of
oh
my
yeah,
favorite movies of all time. He's not the cleaner, he's the wolf. The cleaner is the wolf.
yeah, yeah, right.
Harvey Keitel. Yeah.
On top, thank you. Yes, love Pulp Fiction. Hermit Crab, thank you. Sarah, some days are diamonds, some days are rocks. Walls by Tom Petty. Today's a rock for the prosecution. Free Karen Reed. Thank you, Sarah. Oh no, for your super sticker. We don't know if the verdict. Oh, Adam, we covered this one before. Why no? Trooper Proctor charges TP charges for forgery. We don't know what
Well,
Proctor's going to be.
forging what? There's no
Yeah,
proof yet. I mean, he's not going to get
right.
prosecuted now for planting evidence. I mean, that would come later and probably come in the form of a federal civil rights criminal prosecution against him.
Yeah. Alboret, we thank you for the super chat. Yeah, who knows what thank you, says Dee Dee. Thank you, Dee Dee, for the 10.
By the way, I thought that when you had the ARCA testimony about I don't care about the taillight fragments and all that,
Mm-hmm.
I thought that really substantially increased the likability and plausibility of them planting the taillight to the extent other people were concerned about that, because if it didn't break from the impact, how did it get there? And it had to get there from human hands and da 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 da.
Mm-hmm.
I will bet you that if there is a retrial, that they will probably do a better job of linking that and connecting that, and
Right.
really, because I think that really makes the frame job much more plausible and defeats that kind of stupid argument about, well, how could so many people be involved? Whatever, the science didn't break the taillight, so somebody put it there, and it turns out that these two knuckleheads, Yuri and Proctor, just claimed that it revealed itself over the course of 2 weeks, a little piece by every day. Then I noticed another one of these videos. I mean, this is crazy stuff. I don't know if this was microdots or somebody else, but didn't they? I mean, who has time for this? It's amazing.
I know.
They took the pieces that like Proctor recovered, and they took the pieces that Buchanan recovered. And when they did the reassembly that they did, all of Proctor's went to one section, all of Buchanan's went to, and the odds of that are really slim.
If
Really.
somebody altered that Sally Port video, the inverted one, because when I saw that thing pull into the Sally Port the first time it came up in court, I'm like, oh, that's the passenger side of the vehicle, obviously. And it looked to me like that light was broken. And then when I think it's microdots broke it down, you can see that that was clearly altered. Whoever altered that Sally Port video, I mean, that's a crime.
But once
Like,
you have people appearing and reappearing, I mean, how could that not be altered video, right?
mhm,
I mean, what else do you need?
to make it look like that's the passenger side and make it look like the taillight was broken. To alter that video in such a way that the viewer is thinking that's the passenger side. Look, the taillight clearly looks broken. There's lots of white shining through.
Yep.
Eclectic Mind took a break from technology this past week, and I come here to get info. What the heck is going on? Oh, girl, you're going to have to rewind because it's a lot. It didn't happen this weekend, though. It just happened today. Karen McCourt, thank you, from Canada. My dog just got home from daycare. She jumped up and scratched my arm. Looks like the wounds on John O'Keefe's arm. Just saying, you have a dog that goes to daycare? That is so cute. Guess some dogs need daycare. How does this affect Aiden Carney? Asks Laura.
Uh,
Haven't thought about that at all, actually.
I don't know. I mean, look, the problem they have with that case, or look who the witnesses are, and they're going to come in and say how intimidated I was. I mean, the reality is, if you're the Karen Reed people, hopefully for them, Turtle Boy gets tried first because they're going to just get more damaged.
Mm-hmm.
Another round of transcripts to have at the next trial. I don't know that it literally affects him, other than he's going to benefit that these are not great witnesses who are going to claim that they're scared of little old him, which is hard to believe.
Oh, look at you with the Taylor Swift reference. Who's afraid of little old me? How about
I'd
this?
be so
How
proud
about
I didn't even know. Wow.
Oh, it's the first song on the playlist. Maybe you have the playlist, but oh, thank you, Walter, for telling us Judge Cannoni's the regional administrative judge for Norfolk County. Thank you, Walter. 10. How about this? All these twits out there saying, "Oh, you just wait. You're all going to be sued civilly by the Alberts and the McCabe's. You don't have no idea what's coming." Do you really think
Who's
they're going to
getting?
start suing people civilly and subject themselves to depositions and
No,
every single person to a deposition in their family? Because if it's me and I'm defending someone in any defamation
oh
case that any one of these people brings, I am serving subpoenas on everyone for
oh
depositions. It's gonna
no,
and I will keep them there for days. For days. There's so much to get into. There's no way that's happening. They're just not.
yeah,
They'd be stupid to subject themselves to civil litigation in this case. Just
no, and they're never going to get sympathy. I mean,
to think of the discovery, though. Think of the
oh, God,
discovery.
I
More
can't.
transcripts.
No, and the other thing is this: like, you don't even know what the feds have on the cell phones.
Yeah.
I mean, like, if there's a retrial, are they going to release their cell phone expert who clearly believes that McCabe did the search at two whatever in the morning?
Yep. Mhm.
I would think if there's a retrial, the feds are going to say, "Go ahead, use this person if that's what it takes." So no, I don't think any of these people are suing anybody for anything.
But, that's what they love to spread.
Well, they're
We're
just
all
trying
getting sued.
to.
You and me both. You and me both. We're getting sued.
We're getting
Sleuthing
sued.
around. What?
What am I getting sued
I
for?
don't
What
know.
do you?
Because we've accused people of doing things, and I've never accused anybody of doing anything. But
Me neither.
and people don't understand the laws of defamation. Clearly,
The
sleuthing
only thing
around.
I've said is that Proctor is a scumbag, and I think that the defamation laws are pretty
Yeah,
good on that one.
truth is a complete defense. So sleuthing
There you
around. Proctor suspended without pay today. Thank you. We got the memo on that one. Appreciate your 10. Whatever floats your goat. If the foreperson was picked first, his or her number wasn't in the spinning barrel for alternates. Don't know. Mark McMullen thanks the 10. Maybe Proctor can get a job at TNT Pizza. Oh, Barbara Brady, I think they forget what reasonable doubt means. Thank you for that. Amber, what does the process typically look like for the verdict slip if hung? Will the jury return the slip to the judge, or does it just go into an envelope? It's Massachusetts. I don't know. Do you know?
Well, I don't think they check off anything, but I guess the only concern here is that there's at least three of them that are claiming, but we meant to or we did because we believe she's not guilty, unless you can fashion this scenario where they meant to do it but didn't do it because they got hung up on count two, and then they just said, okay, it's a hung jury, so maybe we don't have to check off the other boxes. I mean, this is a real mess.
Mm-hmm. Why doesn't the clerk have to show the number drawn for the alternate? I'm sure he shows it to the judge. I mean, I think that's, I don't know. All right. Do you think that Paul admitting that he brought the McAlberts on purpose to send a message to the jury is something the defense can use?
No,
Kelly Kell.
no.
Nope. Rody. They narrow down to count 2 for the retrial. Could this help the DA to pivot to a more plausible scenario? He threw the glass at the car. She backed into him, and he hit his head on the hydrant. I don't think they could change their theory now. They're
No,
locked
that's
in.
it. The problem is they're locked in on their factual version, and of course, Trooper Paul's expert opinion on how this happened. They can't transition and just say, forget all that. This is what really happened. They'll get clobbered with the prior testimony and whatnot.
Yeah. How does Paul O'Keefe feel now? Says Virginia Murphy. Thanks for the 10.
That she's guilty. I don't think anything's,
Still.
yeah.
Jennifer Manning, thanks for the 5. I'm from Stoughton. This is a witch trial. They threw her in the water and she didn't drown. So are they declaring her a witch? How is this 2024? I agree with you. Rusty Trike. Cass, I thought it sounded like you can't come out now. Oh, on that audio?
I don't think that's not.
Someone's coming out. Barry Raven says she thought it said someone's coming out to help.
I don't remember the exact words, but I remember thinking it sounds in context not good for them. It sounded like presumed knowledge.
Yeah. Nancy, where did Mark get the amended jury form? I thought for sure Bev said she was not adding the not guilty box.
It was sent to me.
Yeah, but I got it too. Thanks, Nancy, for the 10. Was the glass on the bumper ever explained? Yeah, I think they said it matched to random glass on the street, I recall.
And explain that, by the way.
Right. TA tripling down gives the air of comfortability. Brian LTL's familiar info has been vindicated. I am not sure what that refers to. Mark just tweeted you video of how Sallyport video was manipulated down to knowing the system Canton PD uses. Thank you, Gwenin.
That's interesting.
Does Trooper Paul have an Adobe Premium certificate? Thanks, Techune. Do you think it's more possible, says Lala, than not? Proctor will implicate all involved to get the heat off of him.
I mean, look, if the feds come after him, it's a logical thing. If he says, I'm going down, who do I take with me? Although he would have been in a much better position if he had that thought process before he perjured himself repeatedly at trial last month. So whatever deal he was going to get, worse than it would have been, which, as I've said, I don't understand why he even testified. The reality is if he doesn't testify at the trial and he takes the fifth, some of those texts don't come out yet. He may not have been sanctioned yet. They could have kicked it down the road even further. So, he killed the case for a lot of reasons. He's going to hurt him in a retrial. His career is over. He's got his wife running around saying things I'm sure she's going to regret someday. I
stand by your man.
It's talk about cringe.
Nikki says if retried, the defendant should get a forensic video expert. I think that video was turned over during trial. Like that was insane.
I think if there's a retrial, the advantage they have is the time to learn what really happened in the Sallyport, send subpoenas, discovery demands, and if they solve that, how does the DA proceed if you can figure out who fixed that video?
Yeah, agreed. A lot of new members here that I'm going to thank. So if you are still want to hang around while I thank all these people, you're certainly welcome to.
I'm going to run off for like 2 minutes.
Oh, okay. Thank you.
Bye.
All right. Let's see. To all the new members, welcome. And everyone, please hit that like button again, or I'm going to put the fan up. I'm going to put the fan up full screen before we continue. Please. Appreciate it. There's 17,000. We only have 8,300 likes. Get us up to over, 50%. That'd be so sweet. Maggie became a new member, and Victor Mann became a new member. Whatever floats your goat. Billy Tiblier, Christina Anthony, Jess N, Sarah Me, Lori Live 360 for the win. Gifted 5 memberships. You're so generous to this channel, Lori. Always. Christina Anthony gifted 5 memberships. Thank you, Christina. Paul O'Keefe's Nether Regions became a member. Trisha became a member. Anne, Brown Eyed Girl. Olinka. Nurse Kimberly. Is that Nurse Kim from TikTok? Awesome. Susan Costello. Simon Beebe. Harley 62. Sherry, thank you all for becoming new members. Sherry D gifted not 1, but 2 memberships. Thank you, Sherry, so much. Alfred Wynn Jr., thanks for the 10. Judge Glanville, Judge DeThomas's, Judge Andy Bev, Judge Brennan, even the West Virginia Family Court judge acting as law enforcement. How long will we have to endure judges like this? Listen, people, you don't think in Massachusetts, the judges are appointed. In New York, they are elected. A lot of people don't feel like it's important to go and vote in these off-season or off-year elections for judges. You need to vote for your judges if you have the opportunity to do so. And that is how you do not have to endure judges such as like them. Get out and vote in the local elections. Thank you, Kamala Norris, for your Venmo. You're so sweet. Maureen Francis, thank you. Roxanne, thank you. And Dawn, thank you for the Venmo. You guys are always so sweet and very kind and very generous. Nancy is grateful for our coverage on Venmo. Thank you, Nancy. Joanne, thank you, Joanne, the Cash App, and Justin for the Cash App, who's telling me that Fresh Kills on Amazon Prime for $14.99. I liked it. Yes. My friend Jennifer Esposito, who you may know from Spin City, Blue Bloods, she made a movie called Fresh Kills. It's about a mob family on Staten Island. It's told from the women's point of view in the family, which has never been done before. And it's a great movie. It's called Fresh Kills. And it is available on Amazon Prime or Apple TV, I heard. And it's really great. And I would love for you guys to support her and that movie. Thank you. Sherry, thanks for giving 5 memberships. Free Can't Read 2024. You kind of steamrolled my question. 3 obvious not guilty jurors were removed. The clerk spins that basket and pulls the number for alternate, but no one is shown the number. How do we know they didn't remove a particular juror?
Don't know.
We don't. We don't know unless there's any evidence of that. All right, Mark, we've been on at this for almost 3 hours, so I think we're going to wrap. If you have anything, any final thoughts that you would like to say, we can go with that. Otherwise, people can, I'm sure, catch you tonight. You're going to be at tonight somewhere?
Yeah, no, it's you think it couldn't get any crazier, and I don't know what the word is after crazier, but it happened. I mean, this is
It
unheard.
happened.
3 jurors independently contacting 2 different lawyers over a couple of days, all saying we're reading online reports that are not accurate. We actually acquitted her on certain counts, and
Yep, on 2 of the 3.
And the DA, when presented with a chance to respond, rather than saying whatever normal people would say, is the train keeps it chugging. Can't wait for the retrial.
Can't wait to set a date. Looking forward, he says, July 22nd, they'll be back for something, unless they set a date before then. In the meantime, if anybody gets any responses or any further documents, feel free to email them to me at fanbase@mlittlelaw.com. And to my moderators for keeping it classy today, thank you guys. You guys worked tirelessly. To all the members, all the viewers, replay viewers, love you guys. Please hit the like button on your way out and subscribe. It's free, and hit the bell so you'll know when I go live. And remember, everyone, be cool, be kind, be classy. It's not hard. Really, it is so not hard. Don't go into the cesspool. You might not like it there.
See ya.
See ya. Watch for me on Duty Ron tonight. I'll post it later. Good night, everyone.